Member, hearing aid dispenser.
Marcia Raggio, board member, audiologist.
Dee Parker, board member, speech pathologist.
Alice, oh, I'm sorry.
Kelsey Pruden, DCA Legal.
We're going to skip you, Paul, because you're not here.
Sorry.
That's okay.
Paul Sanchez, Executive Officer of the Board.
Allison Grimes, board chair, audiologist.
Patty Solomon Rice, Vice Chair, Speech Language Pathology member.
Debbie Snow, board member, public member.
Jamie Lee, public board member.
Rodney Diaz, public board member, otolaryngologist.
And members, public attendees or members of the audience are welcome to, but not obligated to, introduce themselves.
Paul, thank you for putting out the word that you wanted more people here. I brought some friends today.
Thank you.
Linda Pippard, Vice President of Clinical Operations for Alpha Business Services and Cash and Treasurer.
Brittany Sheldon, Regional Director of Clinical Services for my therapy company and Director-elect for District 6. I'm Sherry Colberry. I'm the coordinator for the distance education programs at California State University, Northridge. And I'm PJ Seymour. I'm the chair of Communication Disorders and Sciences at Cal State Northridge.
I'm Ronnie Tunick. I'm a speech language pathologist, and I'm on the board for District 6.
I'm Terry Cappy. I'm the practice formerly of schools, and I am on the CASHA board as the secretary.
Mary Ellen Hood, program manager for Chapman University's postgrad.
Elizabeth Pioli. I'm a speech language pathologist and director for CASHA District 7.
Vanessa Kahina on behalf of the hearing care providers of California. Brianne Humphries, board operations manager. Carrie Robinson, board staff. David Joseph, board staff.
And where are the audiologists in the, just kidding. Kidding. Okay, thank you very much. Yeah, we are ringing. Feedback.
We want to ask for public comment.
Well, that's probably a good idea. Before we get going, is there anything that anybody, any of the public attendees would like to comment on? The floor is yours. Okay, then. We're going to move ahead with where we left off last night, which is tab 8 in the board book, and it is the proposed board member manual. And hopefully we've all had a chance to take a look at this. And Paul or Kelsey, do you have comments that you'd like to make before we start going through this?
I'll just start with, as a background, we talked about having a board member manual. It's a very important document. It serves as a guide to the board on procedural matters. It's a good background document to help us in functioning as a board. And we've worked hard to put together a draft manual. It's a living document. It's something that can be revisited and updated. And a good example of the need for a board member manual would be when doing mail ballots. What is the board policy as far as holding a vote for discussion when you're looking? And when I refer to mail ballots, I'm talking about mail ballots having to do with formal discipline. Sometimes we send those out to the board ahead of time so that they can vote on those and decide the disciplinary order for a licensee. So I think what we're going to do here is we're going to have Kelsey kind of walk us through here, talk about those things that we can change, and talk about those things that are law that cannot be changed, that are just for here for information only. Do you have anything else, Kelsey?
Nope. That's,
okay.
Yeah. So the first thing will be on page 7. And that is agenda items. So most of this you can't change, but there is a little piece at the very beginning about how.
Can we just talk about page 5 real quick?
Sorry. Paul would like to talk about page 5 first. So the general rules of conduct. Oh, yes, sorry. So yes, you can change this one, but this is just general rules of conduct that Paul and I have sort of outlined in terms of the expectations of board members. and these really should be your expectations for yourselves. So, are there any questions or changes that, or suggestions that people would like to see? Okay, so moving on to page 7. This talks a little bit about how items get on the agenda and the process for that. So what we've outlined here is that any board member should go to the board chair and copy the executive officer 3 to 4 weeks before the meeting in order to have an item on the agenda. And the reason we sort of built in this timeline was because it takes a little bit to get an agenda together, and then it has to go through different levels of review at DCA, including my office. And so sometimes that can take a little bit. And then we also have to adhere to the 10-day notice requirements. It also has to be posted by the internet team, so it just involves a lot. So that's why we put in this timeline to kind of guide you guys as to how to get those agenda items on the agenda in a timely manner.
Can I just say something? On agenda items, I think it's very important for us to try to have as focused a meeting as we can have. And when we have agenda items, we welcome them. Allison and I will talk about the agenda items and start to draft our agenda as we get closer to the meeting. What would be helpful to us is when we have agenda items is to have background information. I think if you look at it from the standpoint of if someone was to pick up our agenda and our materials, would they know what it's about? Would they know what to do with it? If we just have a piece of paper that says we're going to talk about Slpa supervision, but no one really knows what that means, it's good to have that background information. So that's just a thought. If you have agenda items, it would be helpful to have that background information to work with us on providing that to the board and to the public.
And here where it says it will be a standing item to review the status of future agenda items, so that will be a standing item on the agenda, maybe it already is, and I'm
Yeah,
just
that's-
blanking on it. But
That's general future agenda
that's a good
items.
idea. Okay.
Yeah, it's
Yeah.
generally on most. It's number 10 on our agenda today. So future agenda items.
All right.
Just another thing on agenda items too. I understand that sometimes we don't want to lose things. We think, well, if we don't talk about it at this next meeting, then it's going to kind of fall off our radar. We don't want to just carry items onto our agenda if we're not really ready to deal with those items. And that's why we have our strategic plan and our action plan, so we don't lose sight of those things. So I just want to reiterate that maybe that's not the best way to handle things, to just kind of keep things on an agenda and just keep kind of kicking it forward to the next meeting.
And then I wonder if it's possible, and maybe there are too many items for this to be practical, but if there were a rolling table, which would simply be item, status, pending, so that if I wanted to know, gosh, what's happening with advertising guidelines? We haven't talked about those for a while. Maybe we should put them on the agenda, and I'm sure that there's something happening, and if there were just a table that just said advertising guidelines under consideration by the blah, 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 expect the next announcement in 9 months, I'd be like, oh, okay, it's in process, and that's what I should expect.
We have a document too that we use very similar to that. It's more of an internal document, but maybe we can develop something to share with the board, and it's just our action items document that we use in-house to keep track of that.
I think that'd be great to help us kind of see where we are in the process with these various things that we've talked about, and it kind of seems like they've disappeared, but they're obviously, things are happening behind the scenes.
Okay.
And also, I'm just wondering if maybe, since you want this 3 to 4 weeks ahead of time, maybe 4 to 5 weeks ahead of time, the board members could be emailed saying we're now asking you for agenda items. Here's what was on our list of future agenda items at the previous meeting, because we won't have the minutes at that point, so we won't be able to refer back to the minutes to see what was listed, and that will be a tickler for us to then I'll start thinking about agenda items and providing you with some background information.
Okay.
I thought you did that.
Yeah, that's it.
I thought you sent
Allison,
out
I have a
something like
minor
that.
typo in that
You-
sentence that you pointed out.
Oh, 4 weeks prior to the meeting?
No,
The word
last
prior
one you
is
were saying.
missing.
The last sentence.
In the second line, the word prior is missing.
I
The
noticed,
le-
I provided some background on this Texas case, for example, that we're going to talk about later. That data is not in here. So I presume you look at that background information and decide whether it needs to be shared with the board.
I think in that case, I sent out another communication and,
Can I stop you for a second?
yes,
We need to use the microphone.
okay,
Sorry.
okay. Did you want to repeat the question?
Okay. I was just noticing that I did send background information on one of the issues that's going to come up later today, but those documents are not in here. So I'm making an assumption that you looked at them, you and Kelsey looked at them and decided it wasn't prudent to do that at this point or something like that. So is that true?
I had some background documents that we looked at. It was it was actually a case, and I'm not sure if you sent that to me, but I know I had it in a file and I shared it with Kelsey. Probably wasn't, I don't think it was necessary for us to read the whole case. It was pretty extensive from what I understand. But what we did want was, I think we needed to know what the specific concerns or if you had specific questions on the case. We didn't hear back, so I think Kelsey's going to just give us an overview on that.
Okay, well, we can talk about that when we get
Okay,
to it.
Sure.
And I don't want to lose the thread of what you just brought up, Jamie.
Oh, it says recommend instead of recommended.
Where's that?
Yeah.
The second to last line.
The second to last line, it needs an ED, and the second line under agenda items needs
Prior.
a prior, 3 to 4 weeks prior to the meeting. Okay. All right. Now, sorry to interrupt your flow.
No, that's okay. So, and then we have on the same page, I'm sorry, use of electronic devices during meetings, and this is
What
just
electronic?
So this is partly
They should be allowed.
statute in that you're not allowed to sort of have a serial meeting. You're not allowed to communicate with each other secretly, especially on items that should be put on the agenda and should be in an open meeting. So this just outlines that you shouldn't use those things with the exception of board meeting materials that are in electronic format if you so choose to view your materials that way. And then we're going to go to Chapter 4, page 11. And this is really outlining the officers of the board and the roles and responsibilities of those officers. And it continues on to the elections and vacancies and the creation of committees and the types of committees, as well as committee appointments.
So, so can I comment about vice chair, because this is new information, so you want me to start doing this now?
So we pulled this kind of stuff from different boards and their officer roles, but it should be tailored to your board. So I don't have that type of insight to know that type of stuff. So all I did was just sort of take what I thought were good examples and from other boards. So if you have something that you think, gosh, as vice chair, that really isn't my role, or I don't see something on there that I do see as my role, please let me know, because this should be your document, and it should be tailored to your needs.
I will add that I'm more than happy to take on a new board member onboarding.
Okay.
I think that there's a lot that I can share with them.
Yeah.
So we can actually just maybe cross that out.
Okay, but from now on, budget and strategic plan. Okay. Yeah.
Are there any, and then the committee section, There, you do have one statutorily created committee, that is the Hearing Aid Dispensers Committee. So I just put some background information about that and the requirements of that committee. And then Paul and I, or more, Paul, sorry. Outlined the Audiology Practice Committee, the Speech Language Pathology Practice Committee, and the Sunset Review Committee. As you see there, though, it is the chair's responsibility and role to create these and to appoint members to these and to assign tasks to these committees.
And a committee by definition, other than the Hearing Aid Dispensing Committee, which I realize that that's stipulated what it has to be.
Right.
But a committee by definition does not have a particular number of members.
No, so that sort of gets into the Open Meeting Act requirements and how you want that committee to function. If the committee is just researching or doing stuff, you may want to do an ad hoc committee of 2 members so that they don't have to agendize every time they meet or anytime they sort of discuss anything. But if it's important things that should be done in open meeting, or you feel that the committee needs more than 2 members, then we do have to adhere to the Open Meeting Act that way.
That makes sense.
So when we're talking about committees, that's something that I think is really important for us to look at. Our current structure, we've kind of been following more of a hybrid structure, but in the past, our board would have practice committee meetings. And those practice committee meetings would take place the day before, just like yesterday we did with the Audiology Practice Committee. And then after the meeting, each committee would give a report. We'd kind of go over some of the things that were talked about the previous day, and we would have our board meeting. It seemed like we were spending a lot of time, especially early on, just kind of reiterating what was already talked about. I don't want us to have to limit ourselves to having noticed practice committee meetings. I think there's a lot of good work that has been done with actually just ad hoc subcommittees, especially when it comes to dealing with the professions. If we have something that is specific with speech language pathology, we've had Dee and Patty come to our office and work with us. If it's dealing with audiology, we've worked with Marcia and Allison. So then the question is, where do the public members come in? And I think that's really important. The public members, when we're talking about the actual operations of the board, we really need that input. We need that insight. We need, when we're talking about enforcement, our number one priority is consumer protection. Are we engaging the board enough in that conversation and those discussions about enforcement? It helps to have a committee like an enforcement committee because that serves as a guide, kind of gives us a pulse of the board. When Anita is talking with the Attorney General's office and we're negotiating stipulated settlements, we want to know, especially the public members, how do you feel about a certain theme or a certain issue? So what we may want to do is look at our committee structures. We may want to have a budget committee or an admin committee that deals with those administrative issues that the board has, the strategic plan, or an outreach committee, an enforcement committee, those types of committees, and have meetings, sometimes ad hoc committee meetings that we're actually doing committee work behind the scenes, sometimes when it's appropriate, a noticed committee. But I just don't want us to be limited to these 4 meetings a year. And that also, begs the question, would we benefit from maybe having 3 board meetings and additional committee meetings throughout the year? That's something that I've kind of thrown around. I realize that, there would be a concern. We don't want to have less communication or fewer board meetings, but would we gain something by actually having 1 fewer board meeting, 1 lesser board meeting, and then additional committee meetings? So I'd be interested to hear the thoughts of board members.
Well, if I could just start by saying that I think the composition of this board and the composition of the people that we represent, it is totally logical that we have a 2-person audiology practice committee. We have a 2-person speech pathology practice committee. We have a 2-person hearing aid dispensing practice committee, just because of the way this board is put together. And the nice thing is, is that we can meet without noticing. And then when we report to the full board, we have the opportunity for input from our public members. We have the opportunity for input from public who is here physically or who wants to comment. So I don't think we're closing any doors. We're just being more efficient. So I'm an advocate for preserving the practice-specific two-person groupings that we have.
I guess I feel that it's, we meet sparingly enough. There's things that just sit for a long time because we don't meet more often than quarterly. So I wouldn't want to disturb that system. I think we need to do that. Would it be helpful to have intermediate practice meetings or issue committees? That certainly could happen, I'm sure, so long as we didn't have to physically get together. And if that allows for a two-person conversation about an issue, I think we should explore that. But I wouldn't want to have one less board meeting. It just feels like things would really get lost.
Are there any specific items as far as enforcement that you wanted board or committee input on? Because I think that we all do the votes, but at the same time when we go over enforcement statistics and, for instance, just going over the disciplinary guidelines, I feel like that's a great opportunity, and I think that we've done it very well to have the whole board give input on that. Because, for instance, consumer protection as a public board member is really important to me, but if I read like a particular grievance or something that like a hearing aid dispenser did, I don't know within the practice of it how egregious that is. So, someone else might say like, oh, well, that's not a big deal. It happens all the time. Or some people might say like, oh, that's one of the worst things you can do. But as a public member, I just know I want there to be a punishment for that. I don't know the scale of, so that's why I think the whole board giving input on that is important. So if there were specific, new developments in enforcement that you felt needed more work than we have time for in a board meeting, I feel like that's sort of the tipping point is where a committee becomes important. But I know I serve on a couple other boards where we have a bunch of different committees, but then it becomes very clear that everything that happens in the committee is very important to the whole board. So instead of the committee meeting and giving recommendations to the board, it ends up being that the participation of the full board in that discussion is the most beneficial.
Right, and I think sometimes that, like, disciplinary guidelines are our guide. It's our message from the board. This is what we expect when these things happen. So it's a very, very useful and powerful tool for board staff. Sometimes by the time a decision gets to you, it's after the fact. So not all the time. Sometimes we have very clear direction and a very clear idea of what it is we want to do. There are times that it is important to have input, though. And in some boards, you usually have a board committee and board members take the lead in enforcement. Now, that doesn't mean you're out there investigating cases and reviewing complaints. You certainly don't want that.
You cannot do that.
You can't do that, right. But as far as the, applying the standards and applying the guidelines, that's where it becomes important, because there are some issues that are somewhat gray. Right. There are other issues, not just discipline, but how we, when it comes to administering probation, things like that, there are a lot of issues that surround that. So it would be good to kind of do our homework ahead of time and have some participation from the board. I mean, I think we would welcome that.
So that's like for specific enforcement cases, like this is what happened, this is these are the findings, and then what does the committee feel like? Is this the proper? I guess.
I would say specific enforcement issues, not specific enforcement cases.
Oh, because we have the enforcement guidelines already for specific cases, right?
Right.
Yeah.
Paul, isn't it in our action plan to develop an ad hoc enforcement committee?
Yes.
I believe it is in our
Good,
action
good.
plan.
Yeah.
And it is, from what I understand, not specific cases, but general ways to improve enforcement processes.
Right. And another issue, enforcement is one, legislation is another important issue.
Yes.
Especially with when you have limited staff. We don't have staff that are responsible at this time for just going out and searching legislation and doing the analysis. We have a workload. The department and others come to us. They ask us for not only legislative analysis, fiscal impact analysis, and we have to do that. But it would be helpful to also get that input from the board. This is what we're hearing. out in the field, this is what we're hearing, in the profession, and bring it to a committee and discuss it.
Yeah, a good example of that was the Eddie reauthorization bill that I was aware of, but then we were just trying to keep an eye on it, and that's super important. Yeah.
I was just going to make one comment that it would be, if we have an audiology practice committee, speech language pathology practice committee, I don't see hearing aid dispensers practice committee listed here, so I think.
It's actually listed up.
It's up here.
Yeah, because
Okay.
that's statutorily mandated or by regulation?
Yeah.
By statute,
Yeah,
yes.
good, okay.
Yeah.
The board's required to have that.
And those are two individuals, so we don't have to have it noticed.
Exactly.
It would be, I would love to get our public members more involved by having them in some type of two-person committee so that they could be more involved in non-professional, jargony kinds of things, but broader issues that apply to all boards. And I think that would be really useful to have you all more involved.
And I think what we did in the past, and before I came to the board, in the beginning, we were having these committee meetings, and we did have public members on the committee.
Yeah.
The problem with the committee meetings too is that board members were in our meeting but couldn't participate. So we had a process that was actually restricting board member participation
exactly. Yeah.
instead of engaging it. But with the ad hoc committees, that's just typical ad hoc committee work. That we're talking about bringing it to the board, and the whole board is going to be engaged. I don't see that as a problem.
I guess my point is I'd love for our public members to also be on ad hoc committees as well.
Right.
Okay.
Well, especially in areas like the enforcement.
Exactly.
committee,
Of course.
like
It's
to see
broad.
that.
Seems like
Yeah,
it's
that's
broad.
logical.
very appropriate.
Now, you had referred to the enforcement committee as being ad hoc. Is there a reason it shouldn't be?
It
could be standing.
Yes.
Okay. So in calling for a new committee, can that just be a board chair, executive officer, hey, let's do this? We don't have to have a
Yes.
motion or anything. Okay. Hey, let's do this.
Okay. Something I think that we could just continue discussing, but I think it's good to get to inform everybody this is kind of the direction that we're going.
Well, I agree, and I do, I appreciate the participation of the public members, and I don't want you to be underutilized, and maybe in an enforcement committee would be, that could be a really great place to involve you, and, yeah. Thanks. Oh, because I was looking down there. I just forgot what I said. No, that's not true. I was, okay, so just that it would be a good opportunity to involve our public members in, for example, an enforcement committee where we could have the input not only of the board members representing the 3 practice areas, but in recognizing their expertise in and interest in enforcement.
Okay, and so then, do we have any more comments about that one? We can move on to page 22 then. And this is the mail ballot procedure and mail ballot vote definitions. The definitions part, that's mostly from statute. If you wanted to vote in a different manner that wasn't consistent with the statute terms, that would be okay, but I just use those terms so that it would be less confusing. And then the mail ballot procedure, just really the importance of this one is probably the 4th paragraph about when they're due and the importance of getting them in on time, because when a proposed decision comes to the board has 100 days before that proposed decision becomes effective by law. So if the board does not act on it within 100 days, then it is deemed adopted by law. So, and It's just not good practice to have that happen, and it's really the board's decision. So the board should be making that decision on the proposed decision. So,
In calling it out, do you have a sense that we've had a problem in that area?
no,
Okay.
this is just to memorialize the procedure that you guys have been adhering to, and just to highlight that.
You know, we might want to ask, Anita, are there any, excuse me, are there any issues with the mail ballot process that we'd want to, just to answer Allison's question? That may want to come up here.
Barely.
Yes, please.
Yes, there should be. I think it's two.
Particularly, there's not really a problem. I do find that often I need to send a reminder to board members about the ballot because the due date is approaching and I haven't received a ballot. So, and I typically send a reminder just to the members who haven't submitted a vote. And I have had occasion where we haven't received a vote from some members even after the reminder. So those are the two issues.
Remind me, are these paper, email, or hybrid?
They're email.
They're email,
Mhm.
okay. So I think we do have to recognize the potential for spam filters and just noise in the email box.
It could be a potential.
Yeah.
It could be a potential.
I mean, I think that your emails routinely go to my spam filter.
That's something that you would have to, I think, if
Right,
something
fix.
is in your spam, do something to say it's,
That's right.
don't read this as junk. That's junk mail.
I'm just saying.
This is not junk.
Right, so that's something that each, board member would need to make sure. I know that I've heard and received responses from each member at some point, which would make me think that it would go to their inbox, but I don't know much about computers and how all that works all the time. But so that's the main thing that I know in terms of the mail ballot.
So aside from sending reminders, is there anything else that you think we can do to bring this, I mean, maybe put an exclamation mark on it or something that serves as a marker? The reason is because if these are not done in a timely manner, if it's a proposed decision, there are obviously laws that could restrict us from acting on a decision. And the board never wants to lose that ability to act on a decision. The other issue is with the stipulated settlement, which we commonly see. We want to administer discipline or close these cases as soon as possible. So we don't want to extend those time frames to the degree that we can. So we just want you to really be on the lookout for that. And we accept feedback. If there's something we'd be doing differently, let us know. There were a couple other issues on the mail ballot procedure that Kelsey brought up. If there is a quorum and we haven't heard from anyone, I think we have to make a couple policy decisions here. Do we want board staff to move forward with
The quorum's decision.
the quorum's decision in applying the order?
I would think so. I mean, if there's a quorum, would there be a reason to not move forward?
No, I mean, unless you wanted to hear from every single member.
Or do you mean a majority?
No, it would need to be a quorum.
Uh-huh.
Well, so you'd have to have a majority in order to make the decision, a majority of the quorum. But for example, if she's heard back from a quorum of members that all vote one way or the other, should that be the final decision, or should she be waiting to hear from all board members?
So for instance, let's say she hears from 5 people and only 3 people are in favor of doing this. Now we haven't heard from 4 of you. That's a possible scenario.
That's a problem.
Well, that one you have to wait on.
Yeah.
But if 5 people say yes,
Yeah.
then you should just
Then
go
you have a
ahead.
quorum,
Okay.
and you've got a unanimous vote.
So-
So a quorum and a majority.
Right.
Okay.
So we will add that language into this. The second one is.
Can I just say something? Okay, I guess we could go with that. And the other part of that always had me is because if one member votes hold,
So that's
We're gonna do
it
that
can
one.
hold
So
it.
that's the next one. Is what is the procedure you want for holding? Some boards do 2 members, some boards do 1 member.
And if I could just remind the board, we had this conversation a little over a year ago. One reason at the time, the board made a decision to hold a decision for discussion with 1 vote.
Yeah.
I don't think it's necessarily a bad idea. And the reason we did it at the time was because we were we had some new members, we were all learning together, and we welcomed that discussion. I guess the question now is it necessary to hold a vote when only one person wants to hold, or should we do what some boards do, which is require 2 members to hold the decision?
I think it's still good to do it with one, because one person may just happen to spot something that the others don't. That's just my opinion.
I would have to agree with you. I think if one person on this board sees something, I think it's reasonable that bringing that to our attention, we might all say, oh yeah, that's a really good point. I mean, there's a bunch of smart people around this table, and I think that that's reasonable. And it doesn't seem to add an extraordinary amount of time to, I don't know, maybe theoretically it could, but I think one is a good idea. Jamie, what do you think on that?
I was inclined to say 2, just because if there was something that stood out, hopefully 2 people would agree on that. I know that there have been a couple cases in the past that we did hold, and it ended up being sort of like a misunderstanding or like a misinterpretation of it, and that ends up extending the time that action gets put into place, like we were talking about timelines and everything yesterday. I'm inclined to go with 2, but I mean, it's not.
I do know, though, sometimes one person has held it, and then when we discuss it, we end up having many people end up agreeing with one person. That's just the other side.
We are 9 members on the board, and in cases that all 9 responded, and there's 1 hold and 8 to adopt, I think we should adopt. But in case that only 5 responded and 1 hold, then it's questionable. So I thought it should be, if 8 people voted to adopt or not adopt, but 1 hold, then the 1 hold will not be considered as to hold it. But if less than 8 people voted, then 1 hold will make it.
I can see your point, but that gets into some complicated, if this, then that. We would actually have to have a table. This number of people voted, this number of people said hold. It seems complicated. So
I don't know.
Kelsey, do you think 1 or 2 is typical? I mean, do you have an opinion about what is common practice on other boards?
I've seen both.
Okay.
So it's really the prerogative of the board, what you find to be the most useful, the most efficient, the most helpful.
But also, what do we do in the case then, for instance, if we get a majority and a quorum and everyone says yes, and so they move forward with that action, and then someone trickles in a vote that says hold, and then we have to. So then is it a matter of like, if you want to hold, you better vote first, or?
It'll be a vote.
Well, I think
because then that sort of flips the board policy.
The quorum is going to be, it's going to be on the deadline. So if she has a quorum by the deadline, that's when it will become effective. It won't become effective, let's say on the very first day, we get a quorum, but there's still.
Because I thought that's what we were saying when we discussed that, was if on the first day, like 6 people return yes ballots, then she should just go ahead, because then we're saving that 2 weeks or whatever.
Yeah.
Can I just go back, a real quick background on holding a vote for discussion? I think that's probably something we should maybe make sure that everyone is clear on. We don't want to hold a vote if someone has a question. If you have a procedural question, if you have a legal question, you can contact legal counsel. If you have a procedural question, what do we do in this case, or how do we do something? We don't want to have it's ex parte communication, right? But we do. But it is good to know the procedures and know the processes. And sometimes you've talked to Anita, you've talked to me about these issues. So when we're talking about holding, there's some specific criteria that we discuss here. Hold for discussion may be if you wish to hold some part of the action or have it changed in some way. You may believe additional or different terms or condition of probation should be added, or that a period of suspension should be longer. Those types of issues that we want to discuss.
I want to ask the people who are here more than me if they know if ever happened a case that there was a hold and it changed the decision that the majority took after
Yes.
this, yes?
Yes, absolutely, yes. Yeah.
So
And
this
I've
one-
also been with boards that hold it with 2 votes and have decided later on they want to change it to 1 vote because things like that have occurred.
I think that with what you said, that with one hold potentially changing the course of the vote, I think that one hold should be enough.
But it has to be in by the deadline.
Oh,
by the
yeah.
deadline.
By the deadline.
Yeah.
Yeah. Do we need a motion?
It never hurts.
Okay. I move that the presence of 1 vote to hold will result in holding the decision for board discussion.
Is there a second?
Second.
Are there questions?
Can,
Okay.
can there be a motion on 2?
Well, why don't
Because
we-
I can say
yeah.
no and, okay.
Why don't we just deal with this motion? Do I need to ask for public comment?
Okay.
Please, public. Any thoughts that you'd like to express? Okay. Any further discussion from the board? Let's call for a roll call vote. Amnon?
No?
Yes. Yes.
Yes.
Yes.
Yes.
Yes.
Yes.
The motion carries.
Okay, so that is all that I have in terms of the non-statute or regulation required things. So if you guys are, with the changes that you've made, Paul and I can go back and memorialize those. So would you guys like to put a motion out to adopt it as your board member procedure?
So moved.
Can we?
With edits.
edits.
Okay,
Yeah.
that's what I was concerned
Yeah.
about. Yes,
Yeah.
with the
We made a lot
edits,
of
yes.
changes.
With the changes, and then I also saw that there's, on the table of contents, I need to move a few things around. So we will go through, do all any grammatical, technical errors, as well as the changes that have been discussed today and the one that you just voted on.
And could we also have that included in our board packet next time, just to review now with the
a good idea.
changes? Because all we're going to have is this handwritten dribble that we put in.
Or
Yeah,
even
so-
just send out as an
Yeah,
email.
it can be sent out, exactly. When
Yeah,
it's
that'd be great.
finalized, we will send it out to
Okay.
all board members. Because it does have some good resources in it too,
Yeah.
for you to have.
Yeah.
So, yes, of course.
Jamie, you moved, I'm sorry, yeah, yes. Was there a second?
Second.
D. That was D.
That was, thank you.
You looked around like you didn't
I
know
know,
where it
it's
came
like
from.
some voiceover. I can localize. Is there further discussion? Marcia?
I was wondering if you could add something to the board meeting procedures. You do mention teleconferences, and I think it might be helpful. I know I made the mistake once of offering an address where I would be for the call, and due to circumstances, just didn't appreciate that I actually had to be there. Luckily, I happened to be in the same hallway with Patty, so I was able to participate in that meeting. But I think it needs to be spelled out a little bit how important that is, or what are the rules for teleconference beyond the quorum issues.
Okay, so a little bit with that, my office puts out a guide to the Bagley-Keene Open Meeting Act every year, and that is actually going to be an appendix to this.
Oh.
So that will address it further. The legal office puts out and details all of that goes into detail. So that will be in there for you. And I apologize that it wasn't included in this one today, but it will be a part of, I believe in the table of contents,
Yeah, we talked about it. I think we just.
yeah, so there's an attachment that you guys don't have, so I apologize, but it's a guide to the Bagley-Keene Open Meeting Act, and it does discuss the teleconference criteria.
Okay.
And if you feel that gets lost in being in the Bagley-Keene document, and you feel like we need to maybe add a few bullets at some later date, we could do that too.
Yeah.
So this is only going to be in an email format that we're going to just have personally. It won't be printed out cold and printed for board members to have as a hard copy?
No, we'll print it.
You will?
We will, yes.
Oh, okay.
Thanks.
We love printing paper.
I believe
We can
there's
afford to do that?
I believe that there's a motion,
Public comment?
yeah, on the table, on the floor, wherever it is there public comment on this motion? Are we prepared to take a vote?
What's the motion?
The motion is to accept this document with the amendments that have been discussed and proposed. Microphone. Way too many things to think about so early in the morning. Okay, now let's have a roll call vote.
Yes.
Yes.
Yes. Yes.
Yes.
Yes.
Yes.
Yes.
The motion carries. Okay, ready to move to tab number 2, the foreign educated speech language pathologist applicants and English proficiency test requirements. Patty and Kelsey.
Okay. Since we have a number of speech language pathologists in the audience today, is it all right if I just do a brief overview for the audience? Because I really don't have much new to say. I don't really have anything new to say from our last meeting. But so for our speech language pathologists in the audience, there's this issue of English proficiency for speech language pathologists who have been trained in foreign countries and then moved to California and want to apply for licensure in California. That's what this particular issue is. And there have been any number of concerns expressed by licensed speech language pathologists in the state that we need to have some minimal criteria for English proficiency, both orally and in written form, for that particular population. And we've been struggling with this for long before I've been on the board. I think it started back in about 2008 or so, or even earlier, from a number of previous speech language pathology board members. But it seems like we're really making progress right now in this particular area. So some things that have already been done. We've changed the application process, many thanks to Brianne Humphreys, and we've made the application process be identical to the application process for speech language pathology graduate students trained in the United States. So what that means is that we now need to have evidence of the same academic criteria as far as coursework goes. We have to have evidence of the same clinical practicum experience, and the clinical practicum experience needs to be supervised by a speech language pathologist rather than another professional. The praxis exam, we are now requiring it be taken in the United States rather than in a different country as had been practiced in the past. So we've made, I think, what we'd call significant progress as far as the application process goes and the requirements to become licensed in California. The one piece that remains now is English proficiency requirements. And so what Kelsey is going to comment on today is she was going to look into federal regulations and statutes to see whether there are any issues of concern in that area. And at the last meeting, I provided a matrix of sorts that looked at other healing arts boards in the Department of Consumer Affairs. And I'm going to just say, probably our audience doesn't know what I'm talking about when I say healing arts boards. But our board is in the Department of Consumer Affairs, which also includes boards from healing arts, which are things like medicine, psychology, social work, occupational therapy, physical therapy, and any number of other boards. But those are the healing arts boards, but that have similar types of needs that we would have as far as a profession and as far as individuals applying for licensure who are educated in foreign countries. So in looking at that information, we discovered that there is only one other board that is in the regulatory process right now of having English proficiency requirements, and that is the Physical Therapy Board. And their requirement is the TOEFL, and they have a cutoff score for English proficiency on the TOEFL. The TOEFL is an English proficiency test that's administered by the same group that administers the praxis. It's the very same group. And the individual profession determines the cutoff score. Or the individual group that's requiring it determines the cutoff score. So there's no national cutoff score. It varies from profession to profession. So physical therapy has established a cutoff score, but they're in the regulatory process. So it hasn't finished the regulatory process or become effective yet.
Right.
But we do have that information. And because we are in Los Angeles rather than Sacramento, we don't have physical therapy board representation, but I think our next meeting is in Sacramento, so we'll be able to get a report from the executive officer or the chair or whomever to give us more information on how their regulatory process is going. So that's the background. So now I'm going to turn it over to Kelsey.
Okay, so at the last meeting, I was going to look into some federal regulations. Physical therapy does borrow some from the federal regulations, so we wanted to look at that. What I found is that it has to do with certificates for foreign healthcare workers who are coming to the United States specifically to work in the healthcare field. And the federal regulations have just outlined some exceptions to having to take TOEFL, and those are if you graduated from a college, university, or professional training school in Australia, Canada, with the exception of Quebec, Ireland, New Zealand, and the United Kingdom or the United States, so basically English-speaking countries. And then there are some other exceptions with getting certificates from accredited organizations that the federal regulations have found to be proficient in English.
Did you say the countries again real fast?
Yes. The countries are Australia, Canada, with the exception of Quebec, Ireland, New Zealand, and the United Kingdom or the United States.
Okay, those happen to be identical to the ASHA certification requirements.
Yeah, yeah, and I think physical therapy did the same thing. Yeah. So, and then the federal guidelines also spell out some TOEFL minimum requirements, and I won't go into great detail because really, for our purposes, we need a statutory change in order to effectuate this. So we can look at maybe the legislation that physical therapy did. Like Patty said, they are in the process of having their regulations approved by OAL right now. And so hopefully we'll be able to learn a little bit from their process. But their statute specifically called out TOEFL and allowed them to set their standards.
And that's in statute.
That is in statute, and that's exactly what we will need as well.
Wow.
At this point, we do not have the authority to require the English proficiency, an English proficiency examination. We would need that in statute.
And so for our audience, just so they understand, it requires a statutory change, which is different from a regulatory change. Statutory change is a legislative change. Regulatory change is a process that goes through the board and the Department of Consumer Affairs. So they're two very different issues. However, before you go, legislative change, we do have our sunset review coming up this year, and we can request statutory changes in our sunset review. And I think that is what our intention is at this point. So it's not going to be 3 or 4 years from now. It's going to be quite soon because our sunset review report is due. Yesterday's meeting we learned it's due December 1st, and then there's a process, but it's approved in 2017, if I'm not mistaken. So, so it's actually fast. It's actually faster than the regulatory process right now.
But it would require then us to promulgate regs afterwards.
Yes. Oh. Okay.
Yeah, just to be clear, the PT board passed, or the PT board promoted legislation, and legislation was passed that authorized them to promulgate regulations to set these requirements.
The statute gives the board the authority to then set the standards, and then the board, through the public process and the process established with OAL and the regulatory process, will then set the standards.
Okay. So I take that back. So then after that happens, then we go through the regulatory process.
And that's all I have.
Yeah. Board comment, questions? Public comment, questions? Linda, come on up.
Thank you all so much for keeping up on this topic. I've been following this topic for 10 years with you all, and I so appreciate that you keep moving forward on it. This is not directly related to the language part, but to your earlier comments, Patty. I know there has been the change that foreign trained applicants are required to take the praxis here in the U.S. However, I know when I get praxis reports, there's no indication on the report where the praxis was taken. So my question is, if this is a requirement, how in the world are you going to find out where they took it? The reports from ETS look all the same. They report the test and the score, not the location of where the test was taken.
We can add that to the agenda when we get to setting the
Okay.
agenda. Because it's kind of off topic.
Yeah.
Yeah.
But that's a really good observation.
Yeah, it is.
Yeah.
So thank you.
The other question is directly related to the English language requirement. And I know that you're looking at English language requirements for internationally trained SLPs. However, every year we have many, many international students graduating from programs in this country who have varying degrees of English language proficiency. And yes, theoretically, we would hope that through the graduate programs, they would have some course of remediation or extra special help. But I still interview people that have gone to graduate school in this country who do not, in my mind anyway, have sufficient oral and written English language skills.
And this is something that's not addressed in the ASHA standards for graduate programs?
I would say loosely.
Yeah, very loosely. So I can only speak for San Francisco State, but I'm going to assume that at least the CSUs have similar policies, that there is a certain English proficiency that you have to have in order to attend the university. And I would say that, and the TOEFL is actually one of the tests that are offered. Then you have to score at a certain level on those tests in order to attend as a student at the university. And again, I can only speak for San Francisco State, but I know that we have other universities represented here. We also have a graduation application process, and most universities right now require some type of interview process, and some universities require some type of written process. Many require certain scores on the GRE. So at the graduate level, that is really a university, a department or program decision. It's not a licensure decision. When you graduate from an accredited program in California, it streamlines the process for getting a California license.
And the reason I bring it up is because in the past 2 years, I've had students I've supervised in adult clinic at one of the CSUs who I've had to write remediation plans for oral and written language. Right. So, yeah. But thank you.
Yeah. Thanks, Linda. Please.
And then is that to say that the passing score on whatever we do implement would not necessarily be higher than what would be required by a local or domestic program?
Do we have the authority to set the score?
Yes, we have the authority to set the score. So if we want to make a high score, we can make a high score.
But then that would create that discrepancy of if
it
you
would.
go to school here in California, you speak English well enough to attend a program here, but you wouldn't pass the standards of our licensure application if you attended a foreign school. And I feel like that's just maybe one point we either need to consider or either speak to the schools and do the outreach we were talking about of, you know, making sure that they have candidates who have sufficient English proficiency entering into their programs.
Good point.
Hi, I just wanted to support what Linda said because I see that too out there in the field supervising these individuals, and especially when there's IEPs and the parents can't understand what the speech therapists are saying and there's something lost in the translation, and then when they're working with the children it's the same thing too. So that's a direct reflection on our discipline, on our profession, and so I think this is really something very serious we need to address.
Thank you. I agree. It's kind of a sad irony, but I could imagine that happening. Other comments from members of the public, board members?
So I think our next steps then are when we have our meeting in Sacramento to get feedback, more feedback from the physical therapy board, and then we can probably move ahead with some type of motion to get this all going. Or can we do that today, or do you think it's too soon?
We did not list this agenda item as an action item.
Gotcha. Okay, then we have to.
So I would say that it would be something for, and if you do like a sunset committee or something, that could be something that they could motion to do.
Okay, great. Thank you.
Okay, let's move on to item number 3, tab 3 in today's meeting. Give me this thing. Paul's going to talk to us about auditing supervision of SLPAs.
This is an issue that has been brought up to the board. We've discussed it in committees. And I think what we're trying to do right now is some fact gathering. We know that there are issues out in the field with the auditing of supervision of speech-language pathology assistants, and I think that Dee and Patty are going to probably give us some input here. We've talked about addressing the problem through audits, and I think that when we talk about audits that are done in the office, in-house audits that are similar to what we do with continuing education, based on what I'm hearing as far as what the problems are, I'm not sure that that would be the solution or the answer to dealing with this issue. So we wanted to have a little bit more discussion and talk about what the problem is to help Brianna and I kind of come up with some answers.
Paul?
Yes.
Could I add 3 words to your opening statement here?
Yes.
Because of what I've heard firsthand from Slpas. The sentence finishes, they are not being properly supervised or at all. Some of, and I see heads nodding, some of these people are not being supervised in any way.
Okay.
That would be improper, definitely.
Patty, you had suggested CE audits, but it sounds like the problems that we're having require like more intervention than just.
Yeah, no, I wasn't.
Not a CE audit, but a CE type audit where we would send some type of contact out, ask for some paperwork, and it just seems like, based on what I'm hearing, that it would require more intervention. I think we have to maybe talk about formulating a plan to address that.
Right, yeah. I thought as a way to get us started, it would be useful just to see what our current audit process is for continuing education, or for continuing professional development. But I completely agree that this would need to be more in-depth than simply a list with some checkoff boxes and some documentation with someone saying, I hereby state that I have met the following requirements with their signature. I agree that it would need to be more in depth, and it might require contacting the Slpas that are on the list, and having perhaps a conversation with them. So yes, the answer is I agree.
Paul, part of this also, I think, goes under tab 4, what I've been doing with CTC, and it does address Slpas as well.
So the SLPA issue, just because I don't know, or at least I think I don't know, is it primarily in public schools or is it in all practice settings? All practice settings?
Mhm.
Okay.
It's in all practice settings, but more SLPs work in the public schools than any other practice setting. I mean, that's an accurate statement, I think, yeah.
Yeah.
So do we have suggestions for next steps? Is this something that we need to discuss in a committee, offline?
Can we jump to 4?
Actually, I
Should I
really-
bring up some of the points that I was going to make in 4, or which might dovetail with this, or wait?
I actually think that might be a good idea.
Yeah, that probably makes sense, to move to a discussion under tab 4 and then kind of see how there's overlapping
There is a
concerns.
relationship. Right.
Oh, we'll get them. I know we'll get them. So for just the moment, let's move to the discussion of the speech-language pathology credential variable term waiver issue that Dee will provide a report on, and then we will see how to marry these two issues, solicit
Yeah.
public comment, come up with a game plan that will work.
Okay. The conversations I've had recently have been with Terry Clark at the commission, and a person who's also helping is William Hattrick, who is in charge of special education. That's his areas up at CTC. About 2 years ago, we did establish the criteria for the VTW, have to say, the variable term waiver credential. And essential in there was the fact the person had to have a BA in communication sciences and disorders, a 3.0 GPA, and that was stressed again and again. And they had 5 years to complete their graduate studies. So they were given a 5-year timeline, and that is the number of times they could now renew that VTW was limited. Last year this year, time flies. At our CASHA convention, people were very vocal about the fact that these criteria were not being used out in the public schools. And specifically where it was falling down was the GPA. And going back and looking at how does this happen out in a school district, the person who comes in with a 2.3 GPA does also hold the SLPA. So they're hired on the SLPA, but an administrator notices, wait a minute, they have that BA or BS in communication sciences and disorders. We can make them a VTW, and they don't look at the GPA. So this is how, I've been researching this since April, Beth. This is how they managed to get in under the wire.
Dee, can I ask, and I just don't know the answer, the BA, is it specifically, does it have to be in communication disorders?
Yes, it has to be.
D or related services.
Or the related services,
Yes.
but it is, there are different titles, speech and language pathology. But we were looking for, and what they see is that COMD, CSD, CDS, there are certain acronyms they know to look for, and they are busy. We can address that as well.
But D, it's also for teacher credentials as well. It's both.
Yeah.
Yeah.
We did put the teacher, if they hold that teaching credential, they have a knowledge of the schools. They understand IEPs. They understand children. So rather than just making it COMD or CSD, we said this would be open. And I think many of you in the audience know people who were in the classroom have gone through postbacks and become master's candidates, and they've gone out and they're terrific because they understand schools. And the wonderful thing is they tend to stay in the school. So districts are allowed to grow their own SLPs, and it's worked very well CSUN and NOVA have been champions of this and have really made a difference in the number of SLPs we have in the profession. Recently, I called Terry because I had phone calls from Slpas at the end of their school year who called me to see if their license was in jeopardy since they had never been supervised at all during the entire year. So that raised this issue, and it was interesting. It was anonymous. I couldn't trace it. I couldn't look at it. They wouldn't give their name, wouldn't name the district. They were afraid of their job, but they were worried about their license as well. And when I was talking to Terry, I asked her if administrators in the schools know the difference between SLP and SLPA. And she said, absolutely not. They don't know the difference. SLPA looks like SLP to them. So here's another way that this can go under the wire. And they will put those people out there on the VTW. And I think we have to remember that administrators have a lot they are trying to deal with, and they must have somebody in the building in order to stay in compliance. So what I asked Terry was, now we've had this for a few years, students are getting under the fence, how do we stop it? And I think it begins with education. There is going to be a new special ed director at the Department of Ed as of September 1st. Her name is Kristen Wright, and Terry has already arranged for the three of us to have a conversation. And Terry agreed that education is really where we need to go next, and this is trying to let administrators understand what the SLP is, what the SLPA is, what the SLPA can and cannot do. I went over to our ed admin professor and I asked him, tell me the difference between an SLP and an SLPA. And his answer was, well, one would be a speech pathologist and the other would be an aide. We need to educate. My first step was, I have an hour lecture coming in the fall for his ed admin students. It will at least be a beginning, and we'll get the acronyms across and they will have an understanding. We want this to grow. And we'll try and educate so that they know the difference between these terms. The other thing that happened was some students are applying to universities. They are on that VTW, and they know they don't qualify. But that gives them another year because I applied. That was the criteria you need to apply. That we're going to be addressing as well. It's not just apply, but are you a good candidate? And it's hard even describing to the students, you are eligible to apply for that program. Are you really qualified? Do you meet the higher standard? In other words, yes, you have a 3.0. Did you look at, this is on the website, what was their minimum GPA this year for the students they accepted into the master's degree? That one was missed. We're filling holes, but we are learning, and I do think we've moved in the right direction. Now we're just going to tweak this. They're not aware of the fact in the schools that the SLPA is licensed only. CTC has nothing to do with SLPAs. So part of this is the schools are thinking, well, they're in the schools. CTC is watching over this. CTC is in no way looking at what the Slpas are doing. So at this point, I think we're going to try an education program. We'll start with Kristen and work with special ed through the Department of Ed, continue to work with CTC. It would only be fair to say this works differently in different districts. We've got 1,000 districts in this state, some of them large. I work with LAUSD. I am going to be meeting with a team down at LAUSD, and we'll go through and find out what are the definitions we need to describe to you. What do we need that is very fast, that we can get into the hands of people? And then Patty will go after the CSUs and see if we can get the message out there. And something we were talking about last night, Paul, is, can I bring up about going out to the campuses.
Yeah, it's part of
Actually,
this, yes.
part of this is where the board would go out and meet at different campuses so the students can come and see it is a real body, here are the faces, here's what we do. And that's a good point to tell them, here is your licensure, here's what it allows you to do, and understand what you should do and not do in order to preserve that license. But if they're taught from the beginning, then they know. And I've done this with my students, and they're tired of hearing me say, number one, tell the truth, just up front, fess it, preferably don't do it, and watch the DUI. But they do pay attention. And it isn't something we brought up, it doesn't take long to do, but especially by seeing us on the campus, this will make a difference. And in certain areas, I was sitting with Paul last night deciding, okay, we've got 3 here, we've got 5 here, 7 here, we can group them and make sure that if nothing else, the Nishila people come. And they can take that message back to the Nishila chapter. So I think some of this dovetails with what do we have to do with those Slpas? Well, we do have to find a way to get them observed and on a regular basis. But I found that, and Sherry helped me out here, Irma, when we tell the students that as postbacs or undergrads, aren't they listening when you're talking to them at the master's level? Linda has Nova. They know about this, and now they're paying attention to not just their Cs, but you do have a license, and you have to follow the rules of that licensure in order to stay in practice as well, not just your Cs, and it's more than just get those 24 hours in and send in the check. So, thank you, but we are going to start the education component this fall.
So
it's a process.
This may be a naive thought because I'm not a speech pathologist. For the supervision of Slpas, for the variable term waiver, knowing that we're coming up to sunset review, isn't this an opportunity, and again, this may be just totally naive on my part, is this an opportunity that we could really try and get some legislative support for the concept that we need to hold hands with the Department of Education and do some sort of top down? I mean, there's a lot of bottom up stuff that could be done, but it seems to me that if the California Department of Education, they certainly understand this, if they were willing to really dig into this and hold hands with us to figure out some solutions from the top down, it might be easier than just or it might be a nice complement to going after these two issues on a more local level. Right. Is that naive, or is that something?
No, not at all. That's exactly why Terry said there is a new person coming in. It's Kristen Wright. She emailed her that day and said, let's set up a conversation and start at that level.
And Kristen Wright is with the Department of...
She is with the Department of Ed. She's going to be the new special education director. And perfect. Terry, after we had talked, said, let's go straight up to the Department of Ed.
That's good. I mean, this certainly seems to me would be something, these two items together would be something that we would want to also have prominent in our Sunset Review report as needing maybe some legislative encouragement.
If I might, you have legislation, you have statute right now for the assistant that if you promulgate any new regulations, it shall be in collaboration with the State Department of Education, the Commission on Teacher Credentialing, and the Advisory Commission on Special Education in order to come up with those standards. Cool. So,
comments from the public?
If anybody has a question about it was 2 pages. I sent Terry a 2-page email giving them a heads up, and hopefully the conversation would go quicker. I could send you a copy of what my questions were. And then you'd have that in your hand.
One of the things I think we had talked about or in conversations maybe a year or so ago was perhaps doing a fact sheet sent out to special ed directors and to principals. Has there been any thought to that? I know there was done one several years ago, but when I read over it, many things have changed since then. Has there been any thought on that? That was just a question.
That's part of this, yes.
Thank you.
That's part of this.
Hello, thank you for this opportunity. And I wanted to take this opportunity publicly to thank Dr. Parker for her work on this. I've been talking with her for, gosh, about 6 years now. Started about 10 years ago, concerned about variable term waivers, speech-language pathologist in school, and the lack of supervision. Started talking with Dr. Parker, who put it into perspective and actually worked with CTC to make something happen, where we had been just complaining and not having anything happen. Again, Dr. Parker has been a guiding light in this, and in fact, a lot of people we refer to her, she has helped put on the right track. So again, I really want to publicly thank her for this.
Thank you.
And keep going.
Thank you.
Yes.
Thank you.
I want to put a visual as to what the issue of supervising of Slpas looks like in the schools, because this is what, as I'm out in the schools, I do various assessments and IEEs for districts, and so I'm always nosing around at how the Slpas are being used and the supervision, etc. So what it looks like in the districts who do not do it correctly is they will have one Slpa who goes to 5, 6, 7 schools, and the supervisor on record with the state has nothing to do with those students. So this is how it looks for the most part. And then you have agencies who go in, and this is coming up in a local district right now with an agency. He himself may be the supervisor on record, but he has his staff at the schools. He has nothing to do with the Slpa, supervision, etc. So, and this is it, and this, we have many discussions out in the field about this for those of us who are very worried about it. And that also happens in private clinics as well, much the same way. So it seems like there's a vagueness when I was looking at that handout back there about what you're signing when you're signing on a supervision. It seems like what's missing is the piece that says, as the supervisor, I assume full responsibility for every student that Slpa interacts with. That seems to be the piece that's missing, as well as the education of the special ed directors. The special ed directors truly do have no idea. Yeah. All they want is a body in place. And then in the private practice, I know of private practice who has somebody in San Diego who's the supervisor on record, and the owner of this private practice literally will say, I'll pay you a couple $100 a month to sign on as a supervisor. She herself is doing the supervision, not the SLP on record. And so you have somebody in San Diego who's the supervisor of early intervention clients in Covina and never interacts other than maybe phone. So that's what it looks like, but it's especially bad in the districts. So thank you.
So the word perjury comes to mind. Is that too strong a word? I mean,
well, it's just vagueness, I think, in the licensing. And as an SLP, the SLP who is signing on, if the language was stronger, like I assume full responsibility for every client contact, they're going to back off, and they're going to put more pressure on the administrators and say, I'm not going to do that. But right now, everybody is, the Slpas cannot speak up because they're worried about their jobs. Absolutely. And the SLPs just want relief because they've got, they're spending 6 hours in IEPs every day. So there's not enough incentive. But most SLPs are very much concerned about keeping their license intact and not having any issues. So maybe stronger language, if that can be done at all, but about that statement that says, when you're signing off as supervisor. Mm-hmm. So.
I just wanted to speak from probably a more unique viewpoint than the rest of the members here. I actually was a VTW a few years ago. So my biggest stress would not be so much on the requirements to get the waiver, but looking at the supervision once somebody has them. I was lucky enough to work in a district where I was able to speak up and get what I needed as a VTW, get the supervision that I needed, so I wasn't left on my own. But I have seen several of my friends who weren't so lucky, who were responsible for holding 100 IEPs and they had no idea what they were doing. So I think setting guidelines, I know that's a CTC issue and not so much a board issue, but just kind of helping them set up those guidelines so there is some sort of supervision happening for those VTWs, especially their first couple of years when they're still trying to figure out the whole road. But I would encourage everybody who may not be thrilled with the idea of VTWs, because I understand that there's, you know, varying viewpoints, that I do think it is a really good way to get more people into the profession. And it helped me, and it helped several of my friends become really great SLPs, and they're some of the greatest SLPs I know. Dr. Parker had a lot to do with that as well. But I just wanted to kind of encourage that side of it as well.
That was a great perspective. Thank you.
Yeah. I think that it is important to note the VTW is the speech pathologist of record. When they get that, they are the speech person.
Good morning, I'm Ronnie Tunick. I was a former administrator for speech language pathologists in LA County Office of Education. I had a very large group that I was supervising, but what LACO did, which I think was wise, is that we would give a stipend to our SLPs to support the VTWs. I could not have done my job without that as the administrator, since I had 21 VTWs. And my VTWs in 2006 were just starting their leveling programs. So the other thing that I did is I would do training sessions, because I was very concerned regarding what they knew, and most of them were nascent, didn't know anything. And I think I'm glad to see now that they have to have the degree, the undergraduate degree. I think that the ones that I had, the people that I had, 90% of them went on and got degrees, master's degrees. But the other thing I did is, if I didn't think that they were really were going to be able to get through a graduate program, I wouldn't renew their credentials. I mean, I would fight that with our union. And I think in 3 cases I was successful. The other thing is, as an administrator in LACO, I also receive phone calls from neighboring states asking me if I would take an SLPA who could do an SLP's job. And I was appalled. That would never happen. But there's this undercurrent that I think that's happening to not abide by all the rules that we have set down. So I just wanted you to know that also, and I hear that is happening even today. So it's just a continuing concern. Thank you.
Thank you. Oh, great.
Just a quick perspective from the university side of things. And you mentioned the fact that students who don't get accepted to our programs but are hired on variable term waivers. And before, I guess they just would give a copy of their denial. But lately now I'm being asked to provide a letter for them, letting the board, the CTC, know that they were not accepted, but they had met the criteria for acceptance, and they were not accepted because there wasn't enough space. I haven't actually been looking so much at the GPAs, which I now will, because the minimum standard to apply to the university is lower than the standard to apply to the program. And so there are students with lower than 3.0 GPAs that apply. They, oftentimes don't get very far in our admission process, but they've applied and they've met the university criteria. So I will definitely look at changing that. The other thing is that for those students that are on variable term waivers that are part of the program, in the past, every year I'm asked to write a letter basically letting the CTC know that the students are in good standing in the program, where they are in the program, when they expect to graduate, and those kinds of things. So I've done that for the past few years. What happened this year is that the first few letters that I wrote got rejected, same letters I've been written. But now the CTC is asking that we not only verify that they're in the master's program, but they're also asking that we verify that they're in the credential program, which is interesting and new. So, so anyway, fortunately, I have a really good credential office, and we're working with them because I have no idea who applies to the credential office because that's out of the College of Education. We provide all of the coursework and everything that they need, but they apply directly to the credential program. So I don't know who has applied and who hasn't. I just urge them, if they're interested in a credential in California when they're finished, then they need to apply. We'd rather that they apply sooner rather than later, but you know how students are. Sometimes they wait until the very end, and then it's, you know, a mass hysteria to get all the paperwork in. But now I basically tell the students, you know, this is the new requirement, and I forward the information that I have as to the standing in our program over to the credential office, and the credential office is now writing the letter. So that's fairly new. I don't know if you all knew that, but thought I'd share.
So, can I make a comment?
Oh, yeah, please.
So thank you so much. You know what this tells us? It tells us that the CTC is paying attention
They are. They
to
definitely
these
are.
regulations. They are
They've
paying
sent-
attention to it. They are doing what they need to do to be in compliance.
Yes, and they've sent, I forget what they call, but they're rules, because from my credential office, they sent me a copy of the requirements now. So they're, I forget what they call them, but kind of like their rulemaking or something like that, that includes all of that information, and specifically about being enrolled in the credential program as well.
So it's clearly on their radar.
Yeah, it
The
is.
schools who are hiring the variable term waiver SLPSCs are making attempts to meet the requirements as they are supposed to. And I think that's a very good thing.
Yeah, and most of the time when I get the request, it's coming from their HR people. So their HR people are at least aware of what the therapists that they hire on waivers need to have in order to renew their credentials every year.
And Sherry, that was one thing Terry and I talked about, who are the gatekeepers? And it really should be that HR to begin with, and then you go up the ladder so that these students really shouldn't be slipping under the fence.
Right.
Because there are multiple points to be checked. That's going to be on our list.
Yeah.
Have you followed all those steps?
Thank you. That was helpful. Any other comments from the public? I'd like to ask the board, someone on the board, to propose a motion to form an ad hoc committee to assist staff in addressing this problem. And what did you just say was the second half of that motion that we wanted to have included in that?
I think we probably need to look at our education and outreach. And
Yeah.
we can do some things in the very short term. And we've talked about fact sheets in other areas, and I think it's something that the board has done in the past. It's an effective way of putting that notice out there. This is what your responsibilities are. This is a background. And that can kind of be a precursor to a bigger outreach campaign, a bigger awareness campaign, before we start doing audits and actually look at, you know, the enforcement issues.
Okay,
Yeah,
so
thank you.
would you like to make a motion to form an ad hoc committee with duties as we've discussed?
So move.
Second.
Is there further discussion from the board or members of the public on moving forward with this ad hoc committee? Okay, I'll call for a vote. Rod?
In favor.
Yes. Yes.
Aye.
Yes.
Aye.
Yes.
Okay, the motion carries.
Thank you.
Yeah. Thank you all. Those are
Mhm.
great
Thank you.
perspectives. Yeah.
So can we form this ad hoc committee now, or do we need to wait on that, or how does that work?
You guys can do that. Allison can do that offline.
Yes, we can do it now.
Okay.
Over lunch. We'll just,
Okay, great.
Thank you.
yeah, thank you. That's Okay.
So I think we covered all of item 5, correct?
No, that was
No.
item 4.
But we also
We were-
covered 5 with D, or was there anything else?
3 and 4.
Oh, I'm
3 and
sorry,
4.
Okay.
I was
I
gonna
think
say,
3 and
Sorry,
4, that's
okay,
what I
I
was
skipped.
saying.
You're right.
That we dovetailed that. That's what I thought.
Yeah, if we need to. Okay, are we interested in taking a break?
Yes.
Okay, oh, well, all right, let's take a break. Let's reconvene at 11 o'clock. Plow right on.
Thank you for letting us jump ahead. It seemed to me that.
Report of the Audiology Practice Committee. The Audiology Practice Committee met yesterday, and we discussed a few different items. We approved the minutes from 5/12/16. We discussed the Pcast report, the President's Council on blah, 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 yeah, science and technology. Thank you. Specifically looking at the implications for audiologists and for the general public with hearing impairment, particularly as regards the issue of whether to create a new category of hearing aids that would be over-the-counter without requiring medical clearance or regulation of the individuals that sell the over-the-counter hearing aids. So the Pcast report, there's a copy of it. Is there a copy on the back table? Do you
Yes,
know?
there is.
Copies on the back table, certainly available on all kinds of different websites. And it has, we discussed the implications not only for the profession of audiology, but for the regulations that this board is involved in terms of audiologists and hearing aid dispensers. Again, the Pcast report is advisory, and we discussed the need to keep an eye on this to see how it evolves down the road, and whether we will see changes in the federal regulation of hearing aids under the FDA and the FTC. Staff and board members will, we agreed that staff and board members will monitor the developments and keep an eye on it. Also, in our practice committee meeting, we discussed the ongoing situation with California Children's Services with regards to approving cochlear implantation for children in California who are covered under the CCS program. We discussed the implications for or the appearance of unequal access to care for California children, in that those covered under CCS are able to access a certain level of care when it comes to cochlear implants, whereas children with private insurance are able to access a greater amount of care when it comes to cochlear implantation. We discussed the ongoing challenges in communicating with CCS and getting some clarification on how we can better work together. This issue will be folded into our Sunset Review report upcoming, so that we may be able to get some legislative assistance with this. Are there questions from the public on the Audiology Practice Committee report? No, because there's no audiologists out. Just kidding. I couldn't resist. And I know, I'm sorry, yeah?
Are you talking about the whole agenda of the committee or one item?
No, I was just recapping what we talked about yesterday. So
Yeah,
now I'm
because
going to.
you remember I was talking and you said, no, you cannot talk, you're a board member.
Oh, that's right. You weren't able to talk.
About
Oh,
this.
Amnon, would you like to?
Yes.
But then, since
Yes,
I'm just,
about
well,
it-
wait, just before, I want to get clarification. I'm allowed to do this, right?
Yes, yeah.
Okay.
This is the full board, yeah.
Okay, just want to be sure I'm not
If I'm
breaking
not
any
allowed
laws.
there, not allowed here, I'll better be a public member.
Amnon, write me a letter. Yeah. Okay, please go ahead.
Okay. So yesterday you talked about some manufacturers that lock a software, and by this restricting access to consumers to get service. But there's another issue that I want to also to shed light on this. Like, we're dealing with one manufacturer for 31 years. And you know that the software between manufacturers is different, and software. We have all our computers, everything is software just for this line. So if somebody purchase a hearing aid of company A and we do company B, we tell him we can't do it. So it's almost the same problem.
I feel your pain. Yeah.
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 But I
No, the
think-
pain of the consumer, not my pain.
Exactly. Well, yeah.
Yeah,
Exactly.
yeah.
And I neglected, and thank you for bringing this up, because I did neglect in my report to say that we did talk about the issue of locked software, and I didn't include that in the report that I just gave. So I'll add one more bullet point. We did discuss the issue of consumers who purchase hearing aids where the programming software is locked by the manufacturer or the dispensing entity, and that restricts patients' mobility to go to a different audiologist or hearing aid dispenser to have their hearing aids reprogrammed. Yeah, I left that in. Okay.
I have an experience with this. So the same manufacturers that I'm working with also have lines with software locked to some exclusive dealers. This is the problem, because these lines are very, very small. And it's not like if I will deal with Siemens and somebody will at Phonak, there's a lot of Phonak dealer, a lot of Siemens dealer, but not a lot of dealers that go get exclusivity for something. We have, and this is, the familiar with the board, there was a case here. It's he was fined by the board and took his license, and it was near my office, and dozen of patients came overnight. He fled away from the office, and dozen of patients came to our office for adjusting and programming. And even though we worked with the manufacturer for 31 years, the manufacturer didn't want to give us the software, and the only thing the manufacturer was willing to do, we sent all the hearing aids to the manufacturer, and they unlocked them in their laboratory and gave it back to me so I can go and do it. So sensitive are the manufacturer to protect their dealers. So yeah, that's a concern.
It is a concern, and that's an interesting story. I'm glad you
Yeah.
brought it up, and certainly it is a concern for consumer protection if they're inadvertently buying something that cannot be serviced down the road. So thank you for bringing that up, and thank you for reminding me that I neglected to include that in my report, because we did spend quite a bit of time talking about that. And now I'll ask again, are there any comments from members of the public?
Trying to say something.
Sure.
Okay. Regarding the president, the
Pcast?
The Pcast, yeah. So it was informational for us. Is there any way that we should be responding? Do the audiology members and hearing aid dispensers, members of our board, want us to respond in some way?
You know, I think our professional organizations have responded
Okay.
very strongly, as you might imagine.
Yes.
Perhaps not exactly in the way that, I mean, I can't say what the board would do, but perhaps not exactly in the way that we individually might have responded, speaking for myself. I don't know, is there, we didn't discuss a motion to have this board weigh in on, weigh into the Pcast or to whatever court this is in right now. So we didn't do it yesterday, so I suppose we can't do it today, right, Kelsey?
I think we talked about, this is a recommendation. I don't think we know of any regulations that are being pursued at this time. So I think we said yesterday we were going to wait to see what the outcome was.
Right, but we didn't discuss, we didn't
Yeah.
discuss weighing in as a board, writing a letter to the Pcast or to the FDA or the FTC. We didn't discuss that. So then that really wouldn't be part of my report.
Yeah, I just wrote watch.
this.
Yeah, right, I think that's kind of, but there have been letters in spades that have been written. I'm guessing probably AAO. Do you know, did they write a letter?
Not that I'm aware of.
Not that you're, okay, because certainly the Audiology Academies and, wrote very strong letters.
Are we still working on advertising for hearing aids? Is this still an open issue?
Our advertising
The
guidelines?
yes.
Right, yes,
Okay,
there
so
is.
here is an idea. Maybe in our advertising guidelines, we can put that dealers that deal with such a unique situation will put it in their advertising.
So now we're going back, now we've, okay, so my mind is still on Pcast, but you're talking about the locked software.
I'm talking about some solution to this problem,
To the
and
problem
can be
with the-
done in inserting one item in the advertising guide for these dealers who deal with this thing. They should put it
I
like
see
they
what
have to
you're
put their license number. They have to put this.
Yeah.
For this situation, they should have to put it in their advertising.
So I believe yesterday it was the recommendation that I look into different ways that the board could do that. And so that's, regulation was one of those. So I will look into whether or not we have the authority to do that.
I'm talking about putting it in the guidelines.
Right, in advertising, yes.
Okay.
Well, I think that would be an option. I think what Kelsey was going to do, she was going to look at what the federal regulations are, and if there's any conflict or potential conflict with California, and then we were going to appoint a subcommittee or assign this to a subcommittee to work on it to determine what possible solutions are out there for us.
So we'll make sure to keep you on the radar for that.
Yeah.
And then concerning the Pcast report, again, Rodney wasn't on the practice committee yesterday, so I don't know what otolaryngology's perspective is on this. Can you let us know what otolaryngology's perspective is?
Yeah, I'd have to look into what the Academy of Otolaryngology has sort of officially, and I can report back. But I'm not aware of I get emails from the Academy, but they haven't brought this up. A number of other political issues, but not this. So I'd have to look into it.
Okay, yeah, that'd be good, thanks.
Yeah.
So is there a motion to approve the Audiology Practice Committee report?
So moved.
Second.
Okay, Marcia moved, Amnon seconded. Is there further question, discussion? Okay, let's take a vote by roll call. Amnon?
Yes.
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 The motion carries and the report is
Sorry, I'll pick up.
I need them.
Okay, so Kelsey's going to talk with us about, under tab number 6, the Texas situation.
Okay, so I'm just going to give a brief overview. I want to first start off by saying that, first of all, this case came out of Texas, Texas federal court. So it has not this has not come before California courts. So this at best is persuasive. It's not authoritative. The case is not, at least. But I'm just going to give you an overview, and if you guys do have any more questions or anything with me, just let me know. So this case was brought, it was a class action that was brought by a group of dispensing audiologists and hearing aid dispensers against Walmart, who they were selling hearing aids without an audiological evaluation.
Walmart was doing that, is that
Walmart
correct?
was doing
Thank
that, and
you.
they were not
Okay.
licensed by the Texas Licensing Board, as Texas statute required them to be. So the main questions of this case were whether or not the federal regulations, the Food and Drug Administration regulations, preempted, not trumped, preempted the Texas Medical Board statutes. So, and ultimately the court found that they did. So the ultimate holdings were, first, that the Texas regulations require a consumer to seek out a physician duly licensed by the Texas Medical Board, who specializes in diseases of the ear. And that differed from the federal regulations, in that the federal regulations only required a medical evaluation by a licensed physician. So the distinction was that it was a Texas board certified physician. So the court held that that was not sufficiently related enough to the federal regulations, and therefore the federal regulations preempted them. Second, the Texas Medical Evaluation Waiver provision, which is made applicable to licensed fitters and dispensers, was materially different from the federal counterpart, which permitted sales by a hearing aid dispenser who is not required to be licensed. And third, the Texas licensure provisions that a fitter and dispenser must perform fitting services in the form of a waivable audiological evaluation are different from federal regulations that do not require any audiological exam. So the court did a whole analysis in looking at the Texas regulations and then compared them to the federal regulations. And of note, the FDA Medical Devices Act, which I believe it was like 1977 or 78, we discussed that yesterday, it specifically has a provision in regulations that says that any state law is preempted if it's not substantially related to the federal regulations. So there's an explicit preemption there. And so the court really did an analysis as to whether or not it was substantially related. And another sort of aspect of this was that the court found that the Texas statutes were enacted in order, basically for the safety of the consumer. It was a safety issue. And so because the federal regulations, found that a hearing aid is not inherently an unsafe device, that also preempted it. So it really had to do with the language of the statute itself, and as to whether or not it was substantially related, and then also sort of the spirit of the law, why the law was enacted. And that's what the court looked at. Of note is that California does have two federal exemptions from this act. And those are Business and Professions Code 3365 and 3365.6, which are really outdated, which translates to 2538.37 now, and 2538. I believe it's 38. It's the next one in sequence. But the first one is that no hearing aid shall be sold by an individual licensed under this chapter to a person 16 years of age or younger, unless within the preceding 6 months a recommendation for a hearing aid has been made by both a board certified or a board eligible physician specializing in, I'm sorry, Rod, how do you pronounce it?
Otolaryngology.
Okay, thank you, that one. And by a state licensed audiologist. A replacement of an identical hearing aid within 1 year shall be an exemption to this requirement. And the next one is that a licensee shall, upon the consummation of a sale of a hearing aid, deliver to the purchaser a written receipt signed by or on behalf of the licensee containing all of the following: the date, specifications to make, serial number, etc., the address, a statement to the effect that the aids or aids delivered to the purchaser are used or reconditioned, if that's the case, the number of the licensee's license, and name and license number of any other hearing aid dispenser or temporary licensee who provided any recommendation or consultation, and any terms of warranty. So those we do have specific exemptions from. So that is the case, yes.
I have a question. At the end of all this story, did Walmart is allowed or not allowed to sell over the counter?
So at the end of all of this story, they found that the Texas laws were preempted, and that those laws were not, that they no longer applied. So in those circumstances, as long as Walmart complied with the federal regulations, they were able to dispense. Or sell, excuse me, sorry.
Can they continue to dispense hearing aids without a license in the store? Are they allowed or not?
So again, we have to kind of take this in context. This happened in Texas, and they struck out the Texas statute. So it's my understanding that because of this case in Texas, they did not find that the statutes prohibited them from selling, the Walmart employees.
So today a person can go in Walmart in Texas and buy over-the-counter a hearing aid?
It would appear so.
I have a question. So and this is your opinion, I guess, but that's a good opinion.
Well,
If is this a case where as Texas goes, so goes the rest of the country?
It's hard to say. It's very hard to say. Our language, we have different nuances, different words, and so it's hard to say how we would be affected. It's hard to make that comparison.
Mm-hmm.
Does anybody know if Walmart sells hearing aids in California?
I
don't know.
I
Not
never
that
heard about it.
I haven't either, but so they're not attempting to do that here.
Well, they may be.
Yet.
We just don't know yet.
Yet.
Yeah.
Or maybe
Yeah.
they are, and we don't know.
Yeah. Huh.
Would that then allow a California resident to go to Texas and purchase hearing aids through Walmart without having it been dispensed?
So yes, but they have to waive that right. They have to waive the medical evaluation and all of that.
And they can do that here already anyway.
Yeah. So I don't know. What I don't know, what I can look into, is if Texas amended their laws as a result of this, and maybe what they've done in the meantime. I just kind of looked at the case, but I can definitely look more into the results of what happened after the fact.
Mm-hmm.
This case happened in 2014. So
I would assume that our DCA healing arts boards might be looking at the implications of this across a number of practice areas. And it seems that the implications are potentially profound. So that's quite interesting. So going forward, would it be possible for you to do an analysis for the board to look specifically at the nuts and bolts of this case and the potential implications or things that we should be aware of going forward based on this case, so we can keep this on our radar screen?
absolutely, I can do something where I would probably take the language from our statutes, compare it, show you the comparison to the federal regulations as well as the Texas statutes, and provide maybe some follow-up as to what has occurred in Texas as a result of this.
Yeah, that'd be great.
I remember here at least 3 attempts the last 12 years that came to a proposition or authoring laws in the legislature for over-the-counter hearing aid, which we fought hardly and defeated. So there were attempts by manufacturers to go and do it here in the state, and they were defeated. So I don't believe Walmart is doing over-the-counter here. Otherwise, Costco will not go and have licensed dispenser in each location. They will right away start over-the-counter.
Kelsey, just to go back, you had cited 2 exemptions in California statute. Is that to imply then that because there are no other exemptions in California statute, that California statute would not be overridden by federal statute?
So those 2 are exemptions that were spelled out specifically in the federal regulations. So those are not, those 2 that I mentioned, the federal regulations say that they are they do not preempt ours. The other ones are only preempted if they are not substantially related to the federal regulations.
Okay, so we haven't really looked closely at the language of the rest of whatever statutes control this. So so that's what we'd have to do.
Yeah, so, and it's a little bit difficult because the text, one of the ones in particular that they looked at and they analyzed in this case is one that we have an exemption for. So it's a little bit hard to do that analysis, but especially with what the court said, because we do have that exemption. But I can definitely take a look and spell out exactly what the language is and how it compares for you guys. Absolutely. Are there any other questions?
This has been really, really helpful. Are there questions from the public? Comments? Okay, this was great. Thank you very much, Kelsey. I'd like to move now to tab number 7. This will be the Executive Officer's Report. Take it away.
Actually, what it is it's reviewing the comments for our speech-language pathology assistant regulations. And what we're looking at is we noticed some revisions on a 15-day notice comment period, and we received comments. It's the board's responsibility to review those comments and staff to actually review them, make recommendations, whether to approve or reject the comments. So the first page after the memo is the modified language that you approved at our last board meeting.
And that went out for a 15-day
That's what went out for the 15-day notice. The next document is a summary of the comments from the 15-day notice that ended on June 28th, 2016. Yeah.
Okay, so Karen and I worked together on these. You received 2 comments, and so we worked together to do a staff recommendation to the board as to whether or not, because the APA requires that if you receive comments that you either need to accept the comment and then change and show how you and why you are changing the regulatory text as a result of the comment, or you are rejecting the comment and you need to give a reason why. So we kind of mapped out a little bit of a staff recommendation, and then it's ultimately your guys' decision as to what to do with the language. So the 2 comments are after this summary, and you are required to review them in whole, but then we broke down the different comments from those for you and offered a staff recommendation. So if you guys are ready, I'll just start with the first one.
And this is on the page.
Page 1, summary.
The summary of comments received. Okay.
Yes. So the first is that these comments were not necessarily related to the modified text that was noticed for the 15-day. However, I recommend for transparency that you do make a decision on them as to whether or not to accept or to reject or to accept them, rather than deem them irrelevant. But that is up to you. So the first one says that an anonymous survey should be sent to SLPs and SLPAs who are involved in this process to determine the level of compliance in their workplace and specific issues that they face. And the staff recommendation here is to reject the comment because the board does not have the staff to conduct surveys at this time, and it does not have the statutory authority to require compliance with that survey, and therefore may not be given sufficient responses. And the board also has alternatives for licensees to submit their issues, such as this rulemaking process, public board meetings, and anonymous complaints. So any comments on, how would you like to do this? Would you like to do a motion at the end or do them individually?
Yeah, I mean, I'd like to do it at the end, but what if there's just different, I mean, Marcia, I hear what you're saying, but if they're different, different.
Okay, so since they're broken up, we might as well. So, That's the staff recommendation here, is to reject the comment based on those reasons.
You know, I'll tell you, just from a process standpoint, we probably
It's gonna
should
take
get into the
more
practice of going through all the comments. And then if you have any discussion points or any issues, we can bring those after she goes over the section.
Okay, and as I'm just sort of going through this ahead of time, it looks like the ratio of reject to accept is rather overwhelming, and I also want to make sure that whatever we end up doing, we acknowledge the value of the various suggestions that were made.
Oh, absolutely.
Yeah, and I'm sure you would do that, but.
Absolutely.
Yeah.
So, and the reason that this process is set up is that, the term reject is obviously has a negative connotation, but that's just what the statute calls out, that the board is required to do that. But it does require that the board give the reasoning behind it, and that's really why we make the staff recommendation, and that's why we discuss it as a board, is so that if we do not decide to change the regulatory language based on the suggestion, there is a reason why, and we fully vet that. So.
So just so that I'm clear also, the first comment here, staff recommends that the board deem this comment irrelevant because the comment is not specific to the modified text. Could we just then use that as the reason that we don't consider anything that falls under?
Yes.
Because that, I mean, to me, that would kind of be, hey, these are really good ideas, but you know what? You're commenting on something that we can't change anyway, as opposed to actually.
Well, you can change it. You can change it at any time. This has not been filed with OAL, so. I'm sorry you don't.
All right.
Sorry you don't have it out there. Yeah, but so I actually recommend, for transparency reasons and because that this is such a collaborative process, that you don't want to just, that even though technically speaking we could deem it irrelevant, that we take the time to consider all of these very helpful comments.
Okay, and then reject 9 out of 10.
Well,
sorry.
And just when you're going through the rulemaking process, you know, you do get lots of good ideas, and just because something's a good idea doesn't necessarily mean that it needs to be part of that rulemaking package or stop the original goal of the package. We could actually do some of these things at another time.
Okay.
So just rejecting, as Kelsey said, is a technical term. Doesn't mean that we reject the concept of the idea. We're just having to reject it for the purposes of this rulemaking file.
Right, but there are also some, Kelsey will get to them, where staff has provided us with text to either accept or reject. So we do have some decisions to make.
Yeah. Oh, well, you have a decision on every single one of these. This is just a staff recommendation based on, because, yeah. So.
Well, I had a question, Kelsey. You know, if not us, somebody else might do this, such as doing a survey. Kasha might decide to do a survey, somebody else. That's a good idea. We won't throw the idea out.
Exactly.
And somebody else may pick it up and run with it.
Yeah, good point, Kasha.
I have a question. There's here in the summary, there's item 1 comment from Luis Valente and item 2 comment from Shelly Bader. So there's only 2 people that comment, and all these others, the only 2-person comments?
Yeah, there were two commenters. However, then we broke it down because there were a lot of paragraphs, as you can see.
Yeah.
So we wanted to make sure that every single point that they brought up, you guys
But
considered.
there's 2 people.
2 people, yes. And remember, this was modified text, so I can't remember if you had on the original 45-day. No commenters on the original 45-day. Okay. So, and yes, okay. So that's that one. Okay, so the second one, subsection B, when the SLPA supervision statement is signed, it must be accompanied by a 1-page summary of what the SLPA can and cannot do with laws cited. This must be co-signed by the Director of Special Education or the overseeing supervisor of the SLP. Penalties for misuse must be outlined, and the specific concerns generated by the survey must be addressed. So staff recommended to reject this comment, and then it listed what SLP supervisors sign under penalty of perjury on any application statement, and that's what they acknowledge, and that's outlined there. And I guess the other part of that is that we could not we don't have the authority to require the Director of Special Education to sign that. We only have jurisdiction over the licensing. So, subsection C. A procedure for anonymous consumer complaints must be designed and available for use. A consumer complaint should generate certain action steps. Example given, a letter restating appropriate use sent to HR, special education, and the SLPs in that district. I do not think that districts would continue to misuse SLPs if they were reminded or warned about the abuses. I honestly think that knowledge that there were audits and monitoring methods in place would be a significant deterrent. Once a complaint is generated, increasing monitoring should be a requirement. So staff recommended to accept this comment, but not necessarily change the text, because complaint forms are available on the board's website and can be submitted anonymously, and the board has procedures in place for complaints. It should be noted, however, that the procedures only apply to complaints about licensees, because the board only has jurisdictions over licensing holders. And then staff recommends to reject a portion of this comment because the board does not have jurisdiction over school districts, and therefore it's not feasible to give reminders or warnings, do audits, or increase monitoring of the school districts that misuse the SLPA. And I had put in there just as a note to myself, so I'll bring it up here. We had discussed auditing, and that's something that could happen, but I would advise it to be done in a different regulation package. So I would reject the comment about auditing, but then suggest that it can be something that we use maybe later down the line, because you do have the authority to do so. So subsection D, an SLP who is listed as responsible should be sent a follow-up survey 2 months into supervision, asking how they are completing their supervision, how many hours they are allotted, and reminding them of the legal requirements. This will give the SLPs the teeth they need to make their concerns to the union or their district administrators. A SLPA should be sent a similar survey at least once a year, although they may not feel comfortable being honest unless the changes are made. So staff recommended to reject the comment, and the board does not have the staff to conduct these surveys at this time. Subsection E, in the extreme case of employers who do not comply, revocation of the SLPA and approval should be the final step. And staff recommended to reject the comment. The board does not have jurisdiction over the employer. However, the board will look into promulgating regulations if there is an increase in complaints alleging SLPAs are working outside their scope of practice. And in the case of, subsection, that should be subsection F. In the case of CFRPEs, there is evidence in social media, casual conversation, and many other sources that indicate that supervision is not always being completed according to law. There are definitely employers that are regularly skirt regulations to the detriment of consumers. An anonymous survey of previous clinical fellows, university professors, and employers would reveal patterns of employers who should be sent reminder letters of their legal responsibility. Again, in extreme cases, further RPE-CF candidates should be denied to them. If adequate supervision is not provided, the consumer is directly affected. And staff recommended to reject this comment because this regulation does not address CF or RPEs. Okay, so moving on to the next comment from Shelley Bather. Subsection A, there's a need for clarification and differentiation of the first 90 days, since the level of direct support is different depending on the following 3 situations. The SLPA is new to the field. The SLPA is new to the position or caseload, but has at least 2 years experience as a SLPA. The supervisor is newly assigned to a SLPA who has been in the same role with the same caseload for more than 1 year. Or D, although there are many ways to consider differentiation, one recommendation would be as follows. A SLPA new to the field would have 20% direct or immediate supervision during the first 90 days. A SLPA new to a caseload with experience would have 10% direct or indirect supervision during the first 90 days. And experienced SLPA with a new supervisor would have 10% direct or indirect supervision during the first 30 days. Staff recommended to reject this comment. The SLP is ultimately responsible and accountable for all the work performed by a SLPA. Requiring the SLP to provide 20% immediate supervision to a SLPA during the first 90 days of employment, regardless of experience, will ensure the quality of clinical work the SLPA performs is consistent with their training and experience. In reviewing ASHA's state-by-state page for the summary of state requirements for support personnel, the supervision requirement is in line with the supervision requirements of other states. such as Arizona, Alaska, Alabama, Wyoming, and Oregon. B. Although the notice indicates that there is no fiscal impact, costs to any local agency or school district for which Government Code Section 17500 through 17630 requires reimbursement, none. Unfortunately, there is a significant fiscal impact that will result due to the requirement for immediate supervision during the first 90 days. All supervisors will be required to dedicate a full 20% of their time to supervision, meaning that they will be relinquishing 20% of their own caseload and direct service responsibilities. This is true regardless of setting, in the public school setting as well as the private and medical sectors, adding significant manpower costs to local agencies and school districts. It is possible that government and local agencies will need to hire additional supervisors whose sole responsibility would be to provide this immediate and direct supervision. Either way, the additional costs will be imminent due to increase of need for SLP supervisors, who are already in short supply. Although the costs are significant and must be considered, I believe they are necessary expenses. Separating the supervision into 3 categories I would suggest above would reduce the cost, since the level of supervision would be reduced for situations in which the SLPA has experience. Staff recommended to accept the comment in part and reject the comment in part. The board did not contemplate the additional cost that supervision would require and will consider in the cost in the final statement of reasons. And the rejection would be that although the board looks at cost when considering a rulemaking package, it is not the only consideration. For the other considerations listed above, including public protection, the board believes that the benefit outweighs the potential cost savings.
Please. Yes.
I just wanted to make a comment because we have so many speech language pathologists who are attending our meeting today. And what I'd like to point out is that I hope you realize that a lot of time and effort has been put into comments that were written about regulations. This is what we do for all regulations. Now, we typically don't get any comments, so therefore we don't go through this process. What I'd like to say is, not that we want more work, but please comment, because we listen to your comments and we respond to your comments. And I think that's my editorial about this, that we value what you tell us and we absolutely consider everything that you say and discuss it at our public meetings. And I think that's really important for SLPs who are licensed to know.
Yeah.
So that's my editorial.
Could I follow up on that, Patty?
Please.
One other thing that has come up as a result of this, a lot of our licensees are not aware of the fact that the complaint form is up there on the board and this can be done anonymously. Yeah. And so many people have said to me, oh, I'm not going to say anything because I can't do it anonymously. And immediately you say, go to the website.
Yeah.
So this is a good education, if nothing else.
How do we respond to these particular people? Do they just stay tuned and look at what happens, or do you actually respond?
No, it goes in the final rulemaking package in what we call our final statement of reasons, and that goes to OAL, and it gets put on our website as well. So we have to publish it.
But we don't directly.
respond.
Okay.
No.
Do we send an acknowledgement of, thank you for the time and energy you put into your responses? Your information will be duly considered. I mean, do we send any thank you note?
No.
Okay.
I'm looking at Carrie. No.
Okay, just curious.
I'm sure that could probably happen, but it's not required of us. So.
Well, then if I can just make another comment. It seems like we don't typically get a lot of these types of comments. So, and it's clear that a lot of time and effort and thought went into the comments that these two speech language pathologists made. Is it possible just to say thank you so much? Or
well, I think we're certainly appreciative of public participation in the regulatory process. This is a very technical process. It's something that has to do with rulemaking. I've been in situations where we've actually had to review, I think Karen was with me, we had 22,000 comments.
Yeah, no, I realize that.
And sometimes, I think as as we get out there more and do more outreach, we're going to see more comments.
Yeah.
I think that's going to happen.
I have an idea. Is this website now live streaming?
Mm-hmm.
Yes.
Yes.
Shelley and Luis, we thank you. I'm sure they're watching us.
Good job.
Good.
That's great. So I want to understand that we had 22,000 comments about cats and dogs and 2 comments about speech pathologists.
That's correct. Allison is referring to my former job with another board that regulated
Cats and dogs.
veterinarians.
Veterinarians.
Okay.
So then,
Now we need a motion.
a motion basically to say that we agree with, or we approve the comments that you've made. We don't get to go through and pick apart.
You absolutely can go through and pick
Okay,
apart.
well then-
Because if you want to change it based on these comments, then you should change it based on these comments.
Okay.
These are just staff recommendations based on what the knowledge that we have.
So then we should make the motion first and then have an opportunity for discussion about whether we want to respond to these individually, or how would you like, what order would you like that to go in?
I would say that if people have issues,
Well, I think it's just a matter of, do you agree or disagree with the staff recommendations?
Right, right.
So if there's any disagreement, we should
if there's a
discuss.
disagreement too with the staff recommendation and you are going to change it or add something to it, that we need to discuss that too, because that really needs to be in the record as to why we have to show why we are accepting or rejecting. So.
I really look, well, I mean,
Okay,
yeah,
so-
I really look to you and
All
to
right.
D.
So I so
primarily.
move that we accept the recommendations of staff.
Second.
Okay, is there further board or public discussion on this motion prior to calling for a vote? Hearing none, I'll call for the vote. Rod?
Yes.
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 Yes. Whoa.
Yes.
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 The motion carries. And thank you very much for all the work that went into.
Karen did a great job.
Well, Karen, I'm looking at the wrong person.
Thank you, Karen.
Thank you.
That was a lot of work.
A lot of work, yeah. Everybody, all of staff. Yep. I think we need to, Karen, I'm sorry, can I clarify, do we need to break at 12?
For lunch, yes.
Yes, we need to break. We had specified lunch at 12. Eat fast.
Bring it back. But you can't go.
And I don't know.
Go pick it up
I don't
and-
know the rule. Karen can tell us what to do.
We are going to, those of us that have ordered are going to the restaurant for our pre-ordered meals. Correct?
Okay,
Yes.
so we're going to break for lunch.
Yes, we're breaking for lunch.
What
Eat
time-
fast.
What time are we reconvening?
As soon as you take your last bite.
Well, we should probably let the public know.
Okay, we will reconvene at 12:30 optimistically.
Okay.
We could be chewing, but not swallowing.
Paul will give this report.
Okay, if you look at tab number 8, the memo that's the legislative update, I have just a few things to talk about, some bills that we have been following. And the first bill is AB 1950, which was Assemblymember Mainshine regarding the hearing aids audio switch. This was a bill that the board was opposed to. We actually spent some time talking to the author's office, trying to work with them on some suggestions of some language. We weren't really able to meet consensus, and they went forward with the bill as written. Last I heard, this bill was on the Committee of Appropriations, and that it was put in suspense again. Does anyone have any comments or questions on the bill?
Why was it put in suspense? I'm sorry.
For, I don't know exactly why, but I know it was there for For budgetary reasons,
He
for
does.
budget review.
Why he's not saying
And
the bill
there was some cost to the
Well,
board,
I think the
and some
technical
staffing
thing is
issues.
it's held in
What's your
suspense.
prediction there?
So it's still held in suspense.
Obviously need to continue to follow
so-
up. This is-
but
But it'll be
No, I
out
think
there
that
forever.
the
I
bill's
heard that
dead.
this was already been
Yes.
to
Yes.
this and they
Public
didn't
comment,
approve it.
please.
It was discussed in appropriation
But
yesterday.
what that means when it goes into suspense?
It was in suspense. but they-
And for the record, would you again please
They
state
didn't-
your
and they
name
took it out
and affiliation so that we can have that in the transcript?
Happy to do that, yes.
Okay.
Tony Berrien. I'm number one, I'm a consumer. Cochlear implant, hearing aids, the whole works. I'm also a co-author of AB 1950. And so I'm speaking today on behalf of Deborah Rogers, Roger That Consulting, who's my co-author, who's the other author, and myself. No, I'm not representing any other organization. So yesterday, while we were all sitting in the meeting, I got an email that 1950 is dead. It went through the Assembly, it went through the Senate, and it wound up in appropriations. There was a meeting August 1st, and that's when it went into suspense. On Wednesday, I participated in a conference call with the governor's office, both the co-author and myself, and Assemblyman Mainshine's office. And I'm not really sure why I did that, why we did that, but we got the word yesterday when I'm sitting here in the meeting from Dr. Mainshine's office that it has just been declined. It has to do with the expense. So where does that leave us? I remember talking to Marcia briefly the day that I went to testify. I wanted to explain a little bit how the bill came the way it was because I wished I could have reworded it. So I went to a hearing loss support group meeting in San Diego, and I was demonstrating devices like the Quattro 4. I was demonstrating hearing loops. And everybody's eyes were popping open, and I got the attention of Deborah Rogers, who was a member of the Hearing Loss Association down there. And her eyes just popped. She just could not believe how well she could hear when she used the telecoil in her hearing aid, and had no idea that it was usable. It was a really good meeting. She had a working relationship with Mainshine on a completely different issue. So she says, well, I'll talk to him. I've already tried my assemblyman and it didn't work in 2014. He's not interested in carrying the load. So she talked to Mainshine, and he was very interested. And he also got Mullen involved. Mullen is actually an assemblyman in the Redwood City area, and he's a hearing loss himself. So so that made sense. So they decided, I gave Mainshine's office information from 5 states that have telecoil counseling included in regulations. And so they took that, and then all of a sudden, on February the 12th, I got an email saying that there was a legislation was submitted regarding audio switch, and I said, oh, no, wait a minute, what is that? Because I have alerts set for things that go through the assembly. And sure enough, it was about the telecoil, and it is very, very awkwardly worded. I mean, audio switch, that makes it sound so antiquated, because audiologists here in this room know that you can access telecoil by a button, a switch, a remote control, a streamer. There's so many different ways to access it. So audio switch, I was a little embarrassed by the way that it was written. It was also written to sound like if somebody didn't explain about telecoil counseling, that you'd go to jail. That was not the spirit or the intention that I had in mind and Deborah had in mind, but it was sort of written that way. And we're called the authors and the co-authors, but we didn't even know about it on the day that it was submitted to the Assembly. So now it's dead, but we're not going to give up. So I'm really glad that HP is here and Marcia representing CAA. So just so you know, as well as the board, that we're not going to give up. I'm not so sure that telecoil, to even use that as to improve on the regulations. I would like the audiologists and hearing aid dispensers to explain to their clienteles how to access devices in public venues. Now, for the most part, that's going to be telecoil and a hearing aid. And the American Disabilities Act requires public venues, state, and government, everything but nonprofits. And churches don't have to either, they're nonprofit. But has a device and a headset. And it doesn't work. I have a cochlear implant. It won't work over here. I have a hearing aid over here. I can't put that in there. It's very awkward. It's embarrassing in public. So I always carry a neck loop with me, and I plug it into the device, and I use my telecoil. But nobody knows they can do that. The first time, my big hearing loss support group that I run, I had 60 people, and I put down a temporary loop, and I says, okay, how many people have telecoil? You know, nobody raised their hand. So I sent them back to their audiologist and their hearing aid dispensers, and I said, you probably do, and you just don't even know about it. The majority of hearing aids do have telecoil. And sometimes the ones that don't, if the buyer knew that they could make a different choice and get a telecoil, might choose to do that. I'd just like to see that as an option for people who are spending $5,000, $6,000, $7,000, and now with the Oticon Open, I mean, my gosh, you're you know, spending almost $10,000. So what I want, we're gonna go at this again, and I heard yesterday and I heard today that you really do care about us, and so I would like you to show that. And be part of regulation to require the professionals to help people to enjoy life outside of, you know, just their cell phone. Bluetooth is great for cell phone. You can't use that in a public venue.
Can I just add something? I think it is important to have you participate in this process with the board and to make the board aware of this need for consumer awareness, something that I know in our discussions that was addressed. This is the appropriate place to do it. This is the appropriate place to bring up these issues and maybe put this on a future board agenda so that we could try. You know, we obviously have limited capabilities in reaching consumers. Some consumers are not even aware, or there's a limited awareness of our website. But to the extent that we can partner with professionals and organizations, I'm certain that the board is willing to do that. We talked about consumer fact sheets earlier. That might be something that we could engage the help of others in putting a consumer fact sheet out there and making it available to the public.
Yeah, the reason why this finally died is because of the expense. So the idea is that the board, or I'm not exactly sure who, I think the board was willing to write some language, and this would go into a disclosure, but it would also include information about other features, other like Bluetooth and streamers and the like, and then each person on sale would get this brochure. Well, that sounds very expensive to me. Not only do you have to spend the time writing it, you have to print it, and you have to mail it all over California, and it watered down at the very end that what they wanted to suggest is that we're going to put it on your website so that people could see it. Who's going to see it there? You know? So going forward, you talked yesterday about writing a disclosure for people who are purchasing hearing aids in big box stores and whatever, and providing them with a disclosure about locked applications or, locked app. Well, that disclosure is going to cost you a lot of money. So, it's my understanding. I got a new hearing aid last week. And
Can I just clarify something? There's a difference in requiring the board to provide a disclosure and requiring a seller to provide a disclosure. That language was very specific about having the board develop and provide that disclosure. So I think what we're talking about is just a concept about making sure that sellers inform consumers that this particular hearing aid, and I know we're getting off topic, the other topic, that this hearing aid has limitations. But as far as what we're talking about here, I think that this is an item that we should entertain as a future agenda item to discuss further.
Okay.
Look at ways to help.
In having this discussion, I just wanted to say that the hearing aid dispensers and dispensing audiologists, they use a receipt hearing aid purchase agreement, contract, whatever you want to call it, and you require certain things on there. This licensing board requires certain statements. So how expensive would it be if we had added a statement? They print this, on an as-needed basis. You wouldn't have to print out copies to ship all over. I'm just asking, how reasonable would it be, to require a simple statement that the patient or client signs off that they know, they've learned how to access devices in public?
And I think that's for future discussion.
Yeah.
That's something.
Yeah. No, I think that, I think that conceptually, I would bet that everybody in the room absolutely agrees that when a patient purchases hearing aids, that it is in their best interest, and it's in our best interest as audiologists, to make sure that there's full disclosure of all of the features that are potentially available in hearing aids, whether it's a telecoil, whether it's FM or 2.4 gigahertz or iPhone accessibility. There are so many options now, it's almost overwhelming. It's overwhelming to the audiologist. I think it's especially overwhelming sometimes to the consumers. So I think this is really just one facet of sort of a larger discussion that we can talk about, best practices in having informed audiologists and dispensers, and also informed consumers, because it's helpful for me when the consumer has a good idea of what they want coming into it. So
Right.
it kind of is there's sort of a shared responsibility there.
Well, in accessing public venues, people with hearing aids, unless they're using headphones, they need telecoil. There really isn't. If somebody hands you an FM device, how else are they going to benefit from that? Or in some places they still have infrared, that's really ancient. But and hearing loops, for sure, you need to have telecoil. So and 2.4 gigahertz is wonderful. I'm learning so much about that. It's very exciting. Bluetooth is wonderful, but it's for personal communications. Does not help in public.
Well, I think this is just maybe I realize that the original discussion started with the bill, and the bill is no more, but
Right.
I think that this is a good sort of preview or forecast for an area where the board can in some way perhaps partner with some consumers and really look at what might be an efficient, cost-effective way to help educate the general public about things that they should know about. And so I would like to agendize that for a future meeting.
Wonderful.
And perhaps...
And when this comes up again, it's not going to be just me. The Hearing Loss Association, I'm going to try to engage them to be an important part of this, because they got 21 chapters, so it won't be just Deborah and myself.
Sure.
So we want to
And I think
engage other
that's,
people.
yeah, that's something that Marcia and I can talk about in the Audiology Practice Committee and kind of brainstorm some ways that we can suggest to the full board that we can be collaborative with this kind of
Wonderful.
Of interest.
Well, I love
Yeah.
it so far. I mean, this is the first time I've attended your meeting. I have tried to watch online in the past, and the sound was so poor, and I just couldn't. Didn't get very much out of it. Thank you so very much.
Well, thank you very much.
Yeah.
Is it
I
appropriate for me
appreciate
to
your
say
time.
anything?
Oh, please, I'm sorry. Yeah, yeah, please.
I think if you're going to go at it again, it would be wise to look at why it failed this time. And you've referenced more than once here that it failed due to cost. I think it's essential that you look at what those costs are, why they're generated in terms of enforcement, investigation, prosecution. All of those things are costly endeavors. So when you ask us to simply put something on a document, we have to enforce that it is indeed acknowledged. And what if it isn't? All those things lead to a domino effect of extra costs.
Yeah. I think it's really sad commentary that I find it necessary to even come and have this conversation with you. The fact is, audiologists and hearing aid dispensers are not informing their clientele, and that's why we started this. So I would rather not do this. I have so much other things I could be doing. So we just want the audiologists to do right by the clientele.
They're talking about this in the future and trying to work together, which is excellent, because I don't think the other side knows how the other half lives. And you say, we don't talk about it. Why don't we? Well, there are reasons why it isn't, we're not necessarily disagreeing that it isn't talked about perhaps enough, but there are many reasons why it isn't. And you need to acknowledge those and be aware of them, and perhaps you're not. So a conversation would lead to that kind of dual education about what is realistic and where we can go.
I understand.
Thank you.
So this will be on the agenda at some point, and we can talk about this again?
Yes.
Yes.
Well, and I have your contact information. I'll stay in touch with you.
Thank you.
As far as our future meetings.
Wonderful. Thank you so much.
Are there other comments from board members at this juncture, or from anybody else in the public? Vanessa? Okay, great.
Thank you.
Thank you.
Just very briefly, Vanessa Kahina on behalf of the hearing healthcare providers. We are happy and more than willing to work on the consumer outreach and education piece of this, and was what we thought was a critical component that could have been an AB 1950. We couldn't get to a place on it, but this does seem to be the proper venue for it. And at the time when it's appropriate, if we have a quorum for the Hearing Aid Dispensers Committee meeting, we'd like to see this agendized there as well. Thank you.
Thank you. Thank you. And again, I want to stress that this is the appropriate avenue to address these situations in a board meeting, because there are questions that need to be answered. There's information that we need before we determine what is the appropriate way to address the situation. Is it even a legislative issue, or is it a board initiative? Is it a partnership, task force? There's a lot of ways to address things other than legislation, but certainly appreciate your input. The next bill that we have is AB 2317 by Assemblymember Mullen. And this bill would authorize California State University to award the Doctor of Audiology degree, require the degree be distinguished from doctoral programs at the UC, University of California, and require that the degree be focused on preparing audiologists to provide healthcare services and be consistent with standards of accreditation set forth in the bill. Any questions or comments on? The next bill is AB 28.
There is a question.
Yes.
Hi, PJ Seymour. I'm the chair of Communication Disorders and Sciences from California State University, Northridge. Did you say the degree is awarded through the UC system?
No.
On the transcript, I think it came up as UC.
CSU.
Yeah, this should have been, I'm sorry, this should have been through the CSU.
Right, yes.
Yes, okay. So on the transcript, it came up under UC.
Oh, we better fix
I
that.
think that UC came up because it's distinguished from, there are the UC awardings, and this will be a
is for
CSU.
I just wanted to clarify that. Okay, because as you can probably envision and gather from me hopping up, we're at California State University Northridge. We're very interested in this going forward. We have a lot of interest and have had interest in it for about the last 20 years. So, okay, thank you very much.
Thank you.
Go get her president.
Any other questions or comments on that, on 2317? AB 2859 has to deal with a retired category of licenses. I think currently boards have the authority to promulgate regulations to create a retired license type. This would actually create that in statute for all boards. And the last I heard, this is actually on the consent calendar. The last bill is in suspense, and that's actually a SB 1155 that would have required every program within the Department of Consumer Affairs to waive the application and initial license fee for veterans who've been honorably discharged from the military. And last I heard, that bill is in suspense. Do we have any questions on any of the bills? Yes.
So I don't have any questions on any of the bills, but this hasn't been put on the agenda, so we can't talk about it, but I wanted to alert you to some bills to follow for the future. Can I do that?
Can I speak to this last one first?
Oh, yeah, sure, go ahead.
It's in suspense, meaning that there's costs involved. Do you have any idea what they are? Oh, sorry. Just the last bill, Senate Bill 1155. If it's in suspense, it must mean that there's some high costs involved in it. And I was just wondering if you knew what those are.
You know, I don't know. I just found that out today.
Oh.
Okay. All right. So my comment was this is not on the agenda, therefore we can't talk about it. But I'm wondering if I can mention some bills that we should follow up on for next meeting.
That would be great for future agenda
Right,
items.
when we get to that point
Okay.
at the agenda, we could talk about those.
Will do. I think it's the next.
So that's all I have for the legislative update and review. The next item is number 9.
It's that time of a year. We're supposed to do an annual performance evaluation of the executive officer. I feel like we just did this. What's that? I know, it's so true. I'm assuming that this is something that I can work with staff. Do I need to have, there's a process by which we get board input, correct?
Yes.
I mean, isn't this pretty, as I remember from last year, there's a system for doing this?
Yeah, very similar to what you did last time, and the process is outlined in the memo behind tab 9, and I think it involves Allison soliciting feedback from the board members, and then compiling that information, then having a closed session meeting, and the process is outlined here, and then you would come in and provide me with your evaluation and feedback.
What's the deadline? I always work better with a deadline.
Well, we have a board meeting coming up in November. That might be
Get it done
a
prior to
good
that.
time.
Yeah.
Yes. That item was just informative.
And if it becomes necessary, is there a means by which we could go into closed session by teleconference without noticing it for the public to be able to access it?
Well, you are able to go into closed session in a properly noticed, agendized teleconference. So you have to notice it, but you may go into closed session via teleconference.
Okay,
If I'm gleaning with the...
Yeah, okay, and we would have to notice that, 15 days in advance or
10 days
something?
in
10 days in advance. And I'm not saying it's going to be necessary, I'm just trying to think of how to be efficient, and that might be a way to efficiently do this. So I think, yeah, okay, I'll figure that out. Thank you. Are there questions or comments on item number 9? Okay, let's move to item number 10, where there is a calendar of upcoming events. I noticed, of course, I would notice this, that the American Academy of Audiology meeting was not listed. It is in April 2017, April 18 to 21 in Cincinnati.
There's a space for it.
There's a space for it, but be hard to get there. So this is good to know.
What's the dates again?
I'm sorry?
The dates again?
For 17, it is April 18 to 21 in Cincinnati. And for April 18, it is April 18 to 21 in Nashville. Are there other questions or additions to the calendar to these two calendars? These are just here for informational, I assume.
You mentioned to me the state board, the Association of State Boards.
Oh, the National Council on State Boards. Oh, yeah. That is in October of this year, and I have the dates in my calendar. I think it's like October 18 to 21 in Santa Fe. And I don't have the dates for next year.
Our next scheduled board meeting is in November. There's a possibility that we might have to schedule something between now and November to talk about sunset review and the progress that we've made and items that we might need to discuss. So I realize we're going into a busy time for a lot of us, but that's something that we're going to need to carve out some time for. Stay tuned.
Public comment for items not on the agenda. Okay, this is, or for any, I'm sorry?
Just for future agenda items.
Future agenda items. Okay, future agenda items, public comment. Is there anything that anybody would like to bring up at this juncture?
Oh,
I got you. Oh, I'm sorry.
Did you want, Patty, did you want to bring up the
Well, I
the
got a whole
bills?
list of stuff here, so if you want it.
No, I just wanted to.
Oh,
okay, go for it.
All right, so I've got a list. So we want to talk about the slipper supervision and the SLPSC variable term waiver, and I think you wanted us to set up an ad hoc committee. The other thing I'm thinking, though, is that the SLP practice committee will now just consist of D and me. Is that correct?
Yeah.
So do we actually need an ad hoc
no, you
committee?
don't.
Because we can just
You
do
can
this
talk.
as part of our SLP practice committee,
Yes.
can't we? And we can do, since it's two of us, then we can
Yeah,
do
you can
between
do it.
meetings.
Mhm.
So I was just thinking,
Yeah.
we don't really need
Yeah.
an ad hoc
You're
committee
right.
because that's what it is. So, but anyway, but that would definitely be on the agenda. And then we have the foreign educated SLPs with a report from the physical therapy board. I can mention the different legislative pieces that we should probably be keeping track of. This is many thanks to CASHA Legislative Commissioner Brian Sharp. He sent me a copy of the June legislative report from CASHA. So there is AB 796. There's AB 1715. AB 2004. SB 1034. And then I'm not sure what SCR stands. I think it's a SCR. What does SCR stand for, Kelsey? Is it like a resolution or a
continuing resolution?
Well, no, it's an announcement. It's just honoring May is Better Hearing and Speech Month, but I'm...
It stands for Senate Concurrent Resolution, and I think that might have been CASHA-sponsored
Yeah.
item.
Yeah.
And the senator had at one point in her life been either a SLPA or had involvement in the education system.
Oh, well, anyway, we should acknowledge SCR 136.
Also, briefly on AB 2004, that bill was also held in suspense yesterday due to the mandate cost to health plans.
And AB 2004 was the
Would have
the
required
hearing aid
coverage for hearing aid for minors, yeah.
and it's held in suspense.
Yeah, so because of the cost, it couldn't get out of the fiscal committee.
So is it going to die?
It's done. It's done for the year, but the author is very interested in pursuing it next year as well. His sister teaches in an environment where a lot of children need hearing aids.
Do you recall how many times that bill's already been brought forth?
I think this was this in my memory. This is the fourth time we've attempted.
This is not an agenda
we can't
item,
talk
so
about it.
let's
Okay,
not,
sorry,
let's
sorry.
not engage in, yeah.
Oh, that makes me crazy.
And one more item that I don't know whether it should or should not go on future agendas, but I want Paul to let me know. It's about the occupational therapy issue. Should we put that on the agenda or not?
I think I can look into it and see what their issues are, where they are with their issues, and decide whether it's something we need to talk about.
Okay, thanks. That's it.
Did you want to do the board calendar, the future meeting dates?
Yes.
Okay.
So right now we're looking at a meeting in November in Sacramento. That's November 3rd and 4th. Would you guys like me to contact you about a possible meeting for trying to set up another time if needed for September, October? I think we need to wait and see what we have, what we're working with, but I do think we're going to need to have another meeting. Are there any dates that I should stay away from, or do you guys want to send me that information?
That might be efficient.
Okay.
To just send you.
Yeah.
Okay.
I think it's just going to be.
Paul's looking in October, basically, okay.
So is it already been decided?
September 22 to October 5th,
Oh,
I
okay.
won't be here.
I'm sorry, I got just, so we're going to send you the dates that could work in September, October, is that?
Yes.
Okay.
And our next scheduled meeting is November 3rd and 4th in Sacramento.
We don't need to look ahead to those May and August dates. You don't want to try and forecast where those are going to be or when. I mean, I guess the dates are here. Do we want to forecast the locations or just leave that open?
You know, it's up to the board. I'm open to either way.
Okay, well, that's far enough away that maybe we don't need to deal with it now.
Okay. I would like to in the future consider visiting school campuses, having our meetings, especially during the school year at school campuses, so we could kind of, as an outreach, share the process with the future licensees of the board.
Maybe we could look at that for the San Diego meeting, since they have an AUD program there.
Right.
That might be worthwhile looking into.
Or even, you know, explore places that we haven't gone to in the past.
Yeah.
Okay. That's all I have.
Okay. Is there anything else that we need to do, that we can do? It's not on the agenda. Not on the agenda, okay. In that case, we were almost adjourned.
I know, sorry. It is on the agenda, but I'm not sure if we can go back to an issue. Could go back or no?
You can go back.
Yeah.
Okay. I'm just wondering if you said about writing the letter. I don't recall hearing that, but I could have been daydreaming, so.
Oh.
About for 2317, did you say that, did you discuss?
Oh, yes, for 2317, I think the discussion was whether the board wanted to write a letter of support.
I think the answer is yes.
Okay.
From looking at
Okay.
Marcia's face.
Well, the board at last meeting voted to do that.
Yeah,
Yeah.
that's true. And
Mhm.
okay.
I looked at the minutes this morning, so.
To the governor.
Yes.
A letter
Yeah.
to the governor was